Yes, they are signing.
This 16th.
Day 16th.
The appeal is this way.
That dying declaration.
Huh?
That dying declaration matter. Yes.
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 Dying declaration. It's clear cut.
Mm,
I think you know, the alumni Micros also knows that.
mm.
May I please, Your Lord? I beg to mention item number 3, my lord. My lord, I pray for adjournment of the case, my lord.
Why?
My senior H.I. Chaudhary has some personal difficulty, my lord. Next week, my lord.
Item 3.
Item 3. Yes.
Why do you want to adjourn the matter?
My lord, my senior,
Huh?
he is not well fully.
Who is your senior?
Mr. H.I. Chaudhary, my senior.
H.R.A. Chowdhury.
Yes.
So 1 to 3 you want to adjourn?
No, 3 is
3.
different.
Yes, my lord. 1 also, my lord.
1, 2 are separate items.
Separate item.
No, 1 and 2 you want to adjourn.
No, I am for 3, my lord.
You are for 3.
Yes.
But if and then what about 1 and 2?
No, they are not connected.
They are
I
not
know,
connected.
but then the same lawyer.
Yes, my lord.
Same lawyer.
Yes. 1, 2, yes. 1, 2, even there will be a prayer for adjournment
Correct.
from all
This
sides.
is given to on the same ground.
Mr. H.R. Chaudhary is there for Jashimuddin. And I have also not completed reading the entire death reference case. I have gone through 9 witnesses. There are 24 witnesses. Yesterday we got the
Okay,
list.
right. So 1, 2 also you want to adjourn.
Yes, my lord.
So 3 next week.
Yes.
Okay, right. On the prayer made on behalf of Mr. H.R.A. Chowdhury, learned senior counsel for the appellant, who is reportedly unwell. List the matter on next week.
22nd, 23rd, Thursday, 23rd.
23rd. Then
My lord, 1, 2 after 2 weeks, my lord.
No,
Okay,
1, 2.
voluminous case, my lord.
okay, right.
You do 1, 2.
Adjournment prayer has been made on behalf of Mr. H.R.A. Chowdhury, learned senior counsel for the appellant in criminal appeal number 389/2018 on the ground that he is unwell. So Miss A. Jahan,
S.
S. Jahan, additional PP, submits that she does not have any objection to the same. Accordingly, list this matter after 2 weeks.
To 2 weeks.
2 weeks. Obliged.
My lord, item number 1, my lord. My lord, Lordship speaks 23rd.
After,
No.
after 2 weeks.
Item 3.
Okay.
It is 2 weeks.
You also want to pray?
My lord, I am for the amicus, my lord.
Lordship, I beg to mention item number 6, Lordship. The Lordship matter may adjourn for the day, Lordship.
Why? No more. How can we adjourn all the cases?
Lordship, my senior is not well, Lordship.
You are there. How can we adjourn all the matters?
Lordship, my senior is not well.
Yes. Look, it becomes very difficult for this court to function this way. You all want adjournments. At the same time, your clients are behind bars. You should be, very eager to finish up the cases, in fact.
Lordship, only for the day, Lordship.
Look, the other cases, the counsel was unwell and the other side was unprepared. Understandable. But here, you just want adjournment just like that. If you were in jail, you would want that your case should be heard at the earliest. You've got to think of your clients also. They are in jail, they want a decision either this way or that way. Yes, what to do, madam?
Lordship, since the senior is not well,
Okay, right. Who's the senior?
Noor Muhammad.
SKS.
He's not feeling well.
Okay, right. Adjournment prayer has been made on behalf of Mr. SKSN Mohammed. Learned counsel for the appellant, who is reportedly unwell. Accordingly, release this matter when? When?
Lordship, only for the day, Lordship.
Okay, accordingly, release this matter in the next week.
Official Lordship. So in respect to item number 1, Your Lordship, death sentence.
Yes.
Senior counsel Mr. T.J. Mahanta has been engaged in this as a amicus curiae.
Okay.
His name may be shown, Your Lordship. In
Okay,
item
in
number
that
1.
item 1, you just write for registry to show the name of Mr. T.J. Mahanta as an amicus curiae in death
Death
sentence reference case number 3 of 2018.
Yes. All right.
Give me 4 and 5. You're giving me only 4.
This is against the appeal against the judgment and order dated. My Lordship will find the judgment at page 39.
No, where is the FIR?
FIR is at page 4, my Lordship will kindly dated 4/9/2013.
Yes.
Humble submission is that around 3:10 p.m. yesterday, that is on 3/9/2013, Sri Stephen Dhon and Sri Kishore Dhon, who hailed from our line, chased my elder brother Nasib Munda from his house with stick in their hands and beaten him to death on the road of Bislabari. Thereafter, Kishore Dhon and Stephen Dhon fled from the scene. I therefore pray to take necessary action investigating the matter.
Yes. So let us see the evidence. So what was the charge frame?
Charge is matter under 302. Charge frame and Lordship will find
P6.
is 6.
Charge under
302 and 34.
Page 5.
State of offense that you committed murder intentionally or causing the death of Sri Nasib Munda for your common intention and thereby committed offense punishable under 30234.
yes. Let us go to the evidence.
It was, my lord, there are as many as 14 witnesses, my lord.
Yes.
My
Any
lord, start-
defense witness?
My lord,
Any defense witness?
no defense witness. It starts at page 8, my lord.
Page 18.
8.
8, yes.
Deposition of PW1, that is Dipti Munda. I know the accused persons. The complainant in Mangal Munda is my younger brother-in-law. I also know the disease Nasib Munda. He expired about 2 years back. The disease Nasib Munda was also my younger brother-in-law. During his lifetime, he was unmarried. On the day of occurrence, about 3 p.m., I came to know from nearby people that the disease Nasib Munda was lying there on the road. On the road, Lordship, kindly take note of this. I also went to the place of occurrence and saw the deceased was lying dead. I did not notice any injury on the head, body of the deceased. The prosecution declared this was declared hostile. It is not a fact it is not a fact that I gave statement before the police that Nasib Munda is my younger brother-in-law. In the evening, Kishore Dhan and Istifa Dhan assaulted Nasib with stick. Mommy and I was in our house. I, as well as Mommy, went to the place of occurrence and asked them not to assault Nasib. Both of them chased us from the place of occurrence. After assaulting Nasib, they left the place. Then I went nearby Nasib, but he was already expired on the road. Therefore, we went to our house. Prosecution, it is not a fact that I gave the above statement before the police, and it is also not a fact that I have deposed falsely in favor of the accused to save him from the legal punishment.
So declared hostile.
Was
So
declared-
this PW number one was married to the brother of these two accused.
No, brother-in-law.
She is the
She's-
sister of the deceased, PW1.
Acha, she is the sister of the
The deceased and sister-in-law of the informant.
She is the sister of
The deceased, my lord.
Sister of deceased.
Yes,
but how is
deceased
she
Nasib
the-
Munda was also my younger
No, no, the
oh,
question-
brother-in-law,
Brother-in-law,
sister-in-law,
not-
sister-in-law,
Not the sister, mother. She
sister-in-law.
was sister-in-law of the deceased.
Sister-in-law of deceased.
Yes,
That means she was married
She was
to,
married
to the brother of the deceased and the accused.
accused are different. my
What
lord.
is the relationship between the deceased and those accused, these appellants?
Probably they have, they don't have.
There is a relation.
No, this
I
is-
know the complainant, I know, acha, okay.
no,
The
informant
deceased was my
sister-in-law.
brother. Okay, okay,
Informant sister-in-law as well as deceased sister-in-law.
okay, okay.
Mine.
So no relationship between.
No
them.
relationship between them. In fact, she was declared hostile.
Yes,
Then two, PW2, she is Mommy Munda. She was with PW1 at the time of occurrence. What she says is, my lord, I know both the accused person. The deceased Nasib Munda was my younger brother-in-law. So she is also one of the sister-in-law. This is elder's brother's wife is PW1 and second brother's wife is PW2.
yes.
The alleged incident took place about 2 years back. On the day of occurrence at about 3 p.m., I was in my house while the accused persons were assaulting Nasib Munda with torn firewood,
What
pokakhuri.
do you mean torn?
Torn is
It's a broken piece
Broken.
of
firewood.
firewood.
How can you say torn? Can
It's up to
can you
the-
tear
Because in
firewood?
Assamese it's called hola.
Halakuri.
It's
Khori is a firewood and
This
fala in the sense it's not
I
like,
don't think the translation is correct.
yes,
There cannot be a
sometimes they do
torn
lots of
firewood.
mistakes, my lord.
So what,
It's-
it's a firewood.
it's
basically.
fire.
Yes.
It's fire.
It's a broken one, so
Broken,
injury would
so-
be, I think, to be more.
Torn
Severe.
firewood.
Well,
Hola.
if it's how if it's not a broken one, what will it be? Unbroken
No, your
firewood.
lordship, no. Unbroken is okay. It depends upon where and the intensity of the assault.
Firewood is usually broken up. It's cut with an axe or whatever. You don't. Otherwise, you're going to have a whole tree with you.
Yes, sometimes pieces are small, sometimes it's
That's what it meant.
Okay, then.
On the road near our house, I along with Dipti is the PW1.
Dipti is
PW1.
number one,
Number
3W1.
I along with Dipti went nearby them and tried to separate them to stop the assault. But the accused chased us and as a result, we left the place. After some time, when we again went to the place of occurrence, we saw Nasib Munda. We found that he was already dead. After the alleged incident, the accused left the place. Then we informed the matter to the local person. At the time of occurrence, the complainant Sri Mangal Munda was not present in the house. After uh, sometime the complainant came to the house. On the same day evening, police arrived at the place of occurrence and recorded our statement. So CU was also not an eyewitness.
Huh?
CU was also not an eyewitness.
She was not an eyewitness. No, but
Eyewitness
then you see,
of the-
when in the beginning, in the third line, she says, while the accused persons were assaulting Nasib Munda with a torn firewood
Hmm.
on the road
Then
near
they
the
were
house,
chased away.
I, along with Dipti, went nearby them and tried to separate them to stop their assault.
Stop
So
them.
what
Then,
is
then,
that?
then they were chased away.
Huh?
They were not there.
They were there. Maybe they were not there till the end.
Yes.
But then they saw the assault. Maybe they did not see that
The actual death of the.
yes, at the time of death or the running away or the going away of those persons.
Yes.
But the assault was seen.
Assault person.
Yes.
Now I'll come next one. So on cross-examination, she says, this is Nasib Munda, my younger brother-in-law. The disease was not residing in a garden line.
What do you mean garden line? What do you
The-
mean this
the
line?
Garden, there are lines where the laborers are, they reside.
We are residents of tea garden laborers.
Okay, then
So he was not the inmates of there. The time of our garden line delivery, it takes about 5 minutes to reach our house from the house of the disease. The house of the disease as well as the house accused as well as the disease were situated in the same house compound. As the house of the disease was situated near the house of the accused. So if one has to catch the disease, he would go to catch him by walking and not by chasing him. I have not seen the said torn firewood with which the accused person had assaulted the disease and killed him. Now she says on cross-examination that she had not
no,
seen.
it depends upon the context in which you ask.
Man,
Maybe asking whether he's seen the firewood in the court. When you see in the court, where it does not mean that she says that she did not see it during the time of assault. It could mean that do you see the firewood here in the court today? That question could have been there. And she said, she could have said that I have not seen the firewood today.
verified.
So
Man.
that does not say
The
imply
road,
anything.
the road situated in front of the house of the accused as well as the disease, they were drained by the side of the said road. And there was also boundary fencing around the house compass. Prior to Ellie's incident, the relation between the accused and disease were very good, and they used to make jokes among themselves. The disease was an elder brother was elder than accused persons. The accused used to call disease as their elder brother, Dada. I do not know whether or not the accused and disease used to make jokes among themselves. When I went to see the disease, I did not notice any injury on his body. Prior to his death, my brother-in-law, Nasib Munda, used to take small quantity of liquor. The house of the disease was facing opposite to our house. The house of the disease cannot be seen from our house. If I sit in our veranda, I cannot see the road as well as the house of the disease. When I went to see the disease, he was lying on the middle of the road. Lordship will kindly note. I did not state before the police that the accused person said going to bring the kotari knife from the house of at the time of occurrence. At the time of the road with which the house of the disease was attached, the house of the accused as well as 6 other houses are there. Persons used to reside in the 6 houses. I did not state before the police that the accused also chased the petition other persons who were going to the place of occurrence. It is not a fact that I have disclosed falsely and changed. So she becomes the main evidence panel. Then PW.
And there is nothing to show that her evidence is shaken or that she is not a reliable witness.
No, nothing. to show.
There's nothing to show
Nothing to
that she's
show.
not
But she
reliable.
did not say that the death occurred because of the assault given by
No,
the,
that will be by the doctor.
by the
Maybe.
lordship.
But the fact is that there is no evidence to show that that person was being assaulted by any other person.
Yes. I'll come later now to that part. 3 is is Mangal Munda, the informant. Lordship will see. I know both the accused person. The disease Nasib Munda was my brother, elder brother. He died about 1 year back. At the time of occurrence, I was not present in the house. When I arrived at our house, I saw that my brother Nasib Munda was lying dead on the road. Then I informed the matter to our garden welfare officer, and accordingly, police was informed by the garden authority. Police came to the place of occurrence. While police was examining the dead body of the deceased, I saw that blood was oozing from the backside head of my elder brother Nasib Munda. Police conducted inquest over the body of the deceased. I put my thumb impression on the inquest report. Thereafter, police sent the body for post-mortem examination. I came to know Dipti and Mommy that the accused had assaulted. I came to know from Dipti and Mommy that that accused had assaulted the deceased and killed him. Police recorded my statement. He was the informant, but he was not the witness because he was away from home at that time. Then lordship will come, cross-examination. The third paragraph.
Yes.
The disease used to take narcotic, but I cannot say whether or not he was taking narcotic on the day of occurrence. I do not know whether the disease died as a result of alcohol taken by him and by falling in the drain by sustaining injury on his head.
Yes.
Yes. So, my lord, he relying on the statement of 2 persons, Mommy and Dipti, he lodged them as a relying on the statement of Dipti and Mommy, he lodged them.
So what are you trying to say?
I'll come.
They're trying to say that only one has turned hostile and only one witness. That's what you're trying to say. Other than
that too, she cannot say whether because she says that they were assaulting the accused, disease, and he died later. Then Lordship PW 4.
So we'll have to see. We have to see the quality of the evidence, not the quantity?
Lordship, I'll come to that. Lordship. Now PW 4.
Yes.
She was also declared hostile.
Naturally, she's her
Wife
accused.
Accused.
She declared hostile. That's
But
very logical.
But the story goes, Lordship will see. She says onward that accused is Stephen Horn is my husband, and another accused is so and so is my younger brother-in-law. The disease Nasib Munda was my relative.
So they were related.
So they were related. That's what
Somehow
I'm saying. They were
somehow
related.
related.
Somehow related.
The alleged incident took place 2 years back. On the day of occurrence at about 3 p.m., the deceased Nasib asked me to serve food, and accordingly, I served him with food. And after having food, he asked me if I would give him to commit rape on me. Then I replied that I am his daughter-in-law in relation, and now how he would have sexual intercourse with me. Asking the same, the deceased left our house and went towards his house. On the same day, I heard that the deceased died. After the date of the deceased, I went to the police station and police asked me whether the rape was committed with me or not. Now, during the cross-examination by the prosecution, she says, it is not a fact that I gave statement before the police that today on 3/9, so and so on 3 p.m. I was in my house. My sister-in-law Astami Dhan was also with me. Then Nasib Munda came to our house and caught hold of my body, and he laid a gunny bag on the floor and tried to lay me down on the said bag. When I tried to flee, he caught my wearing blouse, and then my sister-in-law Astami tried to save me. Thereafter, the disease Nasib tried to commit bad work with her and caught hold of her. While my sister-in-law Astami tried to flee, Nasib went out towards his house, and after a while, he again came to our house by wearing a gamusa towel. At that time, my husband Stephen came to our house, and I informed him about the behavior of Nasib. While my husband confronted Nasib, the quarrel took place between them. While Stephen was ready for going his walk, Nasib came and tried to assault him with an axe. By crossing the bridge, Haku made of one single bamboo. Nasib assaulted my husband, then Nasib bite on the hand of Stephen. It is the disease who tried to assault. Then Stephen assaulted Nasib with bamboo stick. Now they say it's bamboo stick. This said stick was a dry bamboo stick. Nasib sustained injury on his head. Then Nasib fell down into water, and Kishore and Stephen killed him by drowning him into the water again and again. Lordship will see, killed him by drowning in water again and again.
This statement is, by the way, by the wife
By
of the appellant.
Accused, yes.
That's he retracted. That part she retracted afterwards. So she was declared hostile. Now the entire judgment revolves on this evidence and evidence of PW2. Now 5, PW5.
PW5 that says nothing.
Says nothing.
6 also
5,
says
6
nothing.
also says nothing.
Doctor,
7 is the doctor. 7 is the doctor, my lord. Death due to coma as result of head injury. Death was opinion, my lord. The death was due to coma as a result of head injury sustained as described. All injuries are antemortem caused by blunt force and homicidal in nature. Approximate time so and so, so and so.
come to page 19.
Yes, please.
Opinion.
Sufficient to cause it. But lordship, prior to that, your lordship will see on examination of the thorax, lordship,
Yes.
thorax, walls, ribs, and cartilages are healthy. Pleura, larynx, trachea, both the lungs are congested. Trachea contains sand particles, lungs are congested, voluminous, and dissection blood mixed with fluid came out.
Yes.
On examination of the abdomen, all the organs are congested, kidney is congested, stomach is healthy and empty, small intestine healthy, filled with digested food material, large intestine healthy, filled with gases and fecal material. My lord, the disease lung and trachea were congested with mud and other things.
Maybe. But then the doctor's opinion is more important.
Yes, he says, my lord,
The most important thing.
and injury, he says injury number 5 and 6 are individual and collectively sufficient to cause death of the disease in the ordinary course of nature.
Yes.
Then 8 to 13,
Yes.
they only heard and they did not have any file.
So hearsay evidence.
Just a minute.
Huh? PW 8 to 13.
8 to 13. Okay, no, 8 to 13. The 14 is the police officer, man.
Age
28.
18?
For 28
28.
is the police officer. CW 14. On 27/9/13, I was posted as SI of Sabua PS. On that day, OC Vijay Kumar Burman handed over the CD of Sabua PS case number so and so under section so and so. Receiving the CD, I found that SI so and so had already investigated the case. Then I collected the post-mortem report of the above mentioned case, and after raising the CD, submitted charge sheet against Stipendon and Kisordon under section so and so. Exhibit 4 is a charge sheet, wherein Exhibit 4.1 is my signature. On 4/9/13, Vijay Kumar Burman was serving in OC of Sabua Police Station on that day. He received an FIR from Mangal Munda and registered Sabua PS case number so and so under section so and so, and directed SI Ganesh Kumar to investigate the case. Exhibit 5 is the said FIR. 5.1 is the signature of Vinay Kumar Burman directing the SI Ganesh Kumar to investigate the case. I know the signature of Vinay Kumar Burman as I was working with him in the same police station. SI Ganesh Kumar passed away. PW1 as stated under section 161 CRPC, the earlier part.
So he's the second IO.
Second IO. Second IO.
First IO was not examined.
He was not, he died.
He died.
He died.
He died before charge sheet was filed. Correct.
Before surgery. Yes. When he says the retracted part of the statement of
Retracted? What do you mean? Where's the retraction?
my lord, she
Can you
did not
retract?
admit.
Can you?
161 statement, she did not admit subsequently.
Okay.
The 30 page 13. By crossing the bridge Haku made of the single bamboo, Nasib assaulted my husband. Then Nasib bite on the hand of Stephen. Then Stephen assaulted Nasib with bamboo stick. The said stick was a dry bamboo stick. Nasib sustained injury on his head. Then Nasib fell down into the water, and Kishore and Stephen killed him by drowning him into the water again and again. Exhibit 7, this is the statement. This was the statement, my lord, by he was killed by drowning in water again and again. Exhibit 7 is a statement recorded by so and so, Ganesh Kumar, wherein the exhibit signature of so and so. I know. I conduct the investigation of this case. I have not seized any bamboo. Madam, Lordship will kindly note. That was not seized.
What was not seized?
The stick or whatever.
The wood, the firewood.
Firewood or whatever.
I think that's
That was
the word you all use, no? The torn firewood.
Torn, subsequently they say it's bamboo stick.
No,
And-
bamboo stick has been stated by this wife of the accused
Man,
under 161 which she has retracted during the evidence
Yes.
before the court.
Yes, but that has been taken, considered in the judgment, lordship
In the judgment.
comes subsequently. Ma'am. So now they say it's a bamboo stick. On cross-examination, he says, I conduct the investigation of the case. I have not seized any bamboo in connection with the case. I have laid charge sheet against the accused person after going through the statement and after considering the earlier IO, as I have not conducted the investigation. I have given charge sheet on the basis of the investigation of the earlier IO. Then my lord, accused person, it is case of total denial. सुविधा के लिए क्या होगा? सुविधा तो मिले क्यों होगा? Now, lordship will come to question number 5 at page 33. Question number 5. PW4, Srimati Sabita Dhan, wife of Stephen, was given evidence that on the day of occurrence, at about 3 p.m., Nasib Munda asked her to serve food and she served him with food and whether he asked her if she would allow her to rape her. Then she replied that she is the daughter-in-law in relation and how he would have sexual intercourse with her. Asking the same, Nasib went to our house, went out of the house and left towards his house. On the same day, she heard that Nasib died. Thereafter, she went to the police station and police asked her whether rape was committed on her own. What do you have to say? They say the allegation against Nasib is correct.
See, one thing,
Wife.
so he agrees with the statement made by his wife that the deceased had asked for the sexual relation.
Favor.
They've used the wrong word here, right? It's should be sexual relation. So sexual intercourse or whatever. So that is, but the fact is that this portion, he has agreed that this had happened. The appellant has agreed that this incident happened when the deceased had made a suggestion to her to have sexual intercourse with him.
Yeah.
Correct. Now, the wife, on the other hand, has denied this entire statement.
Denied.
So, what does that make her?
Because subsequently lordship will come in the judgment. That has been taken considered. That part has been considered.
Yeah.
So lordship will come to the judgment.
So, anything else in the 313?
Question number 17, plea of alibi has been taken.
Huh?
Question number 17, page 36.
Question 17.
I was working in the police.
This is not fully.
Do you have any?
What is the full sentence? Where is the?
Lordship, it's not.
Yes.
Yes, I see
The records.
Lordship, on record, it's not there.
Hmm?
Let me check, my lord.
Question number 17.
Just a minute, your lordship, I'll just. Stephen Dhun, my lord. What is Stephen?
Stephen.
Stephen Dhun, question number
No,
17.
this is examination of Kishore Dhan.
Okay, Kishore Dhun. Lordship, I was not in my house on the day of incident. I was walking in the factory. Police called me from there and told me that I have killed Nasib Munda and went to factory. I was taken to PS. But that's it. ma'am.
That's all.
Yes, I was taken to PS.
Yes.
Then, my lord, the judgment, it starts from 39.
Page.
Page 39 it starts. Points for determination of the My lord, if
Yes.
earlier part I read from paragraph 25, ma'am. 25, at page 53.
53. Earlier portions are
The repetition of the-
repetition of the evidences. ma'am.
Nature of death of Nasib Munda. From the evidence on record, it is not disputed that one Nasib Munda died. Has you also got it, madam?
Page
Page 53.
53.
Para 25.
Yes.
From the evidence of record, it is not disputed that what Nasib Munda died. It is further clear that the dead body of the deceased was lying in the road, Lordship will kindly, in front of the house of the accused and deceased, both the houses being adjacent to each other. The road being accessible through a single bamboo bridge with drain beside the bridge, as would be evident from the version of PW4 Sabita Dhan. PW10 witnessed the inquest conducted on the dead body of Nasib Munda and further confirmed that police had taken the dead body of Nasib Munda for post-mortem examination. From evidence of PW7, Dr. Swenso, who conducted the post-mortem examination of the dead body of Nasib Munda, it is seen that death was due to coma as a result of head injuries as described. The post-mortem report, Exhibit 1, so and so. Injury number 5, bulky swelling over the left parietal area. And injury number 6, bulky swelling over the right peripheral area, were individually as well as collectively sufficient cause of death. PW7 further opined that all the injuries are antemortem and caused by blunt force impact. From the evidence of PW7, it is clear that death of Nasib Munda was homicidal in nature. The defense suggestion that in this report, in this respect, to PW2 and 3, PW10 and 11, is that Nasib Munda used to consume alcohol. And on the fateful day, he fell after consuming alcohol, because of which he died. All the said witnesses in their cross-examination admitted that the deceased used to consume alcohol, but have not stated that they cannot say whether the injury on the person of Nasib Munda was due to having fallen on the road. This suggestion does not assist the defense, inasmuch as the nature injuries clearly suggests otherwise. The fact no such suggestion has been put to the respective expert PW14 to dispel his opinion that nature of death was not homicidal and that it was because of the fall. It is therefore to be ascertained how Nasib Munda sustained injuries on his body leading to his death. Now comes eyewitness. PW2, Srimati Mommy Munda is a crucial witness who has categorically stated that when the accused persons were assaulting Nasib Munda, C and PW1 Dipti Munda tried to stop, but the accused seized them. And when C and PW1 came back, they found Nasib Munda lying dead on the road. PW1's Nasib Munda resigned from her earlier statement before the IO, where she had also stated that accused person and she had gone to ask accused person not to assault. However, the accused person chased them. After assaulting, they left, and when they went near Nasib, he had already expired. PW4, Sabita Dhan, wife of accused Stephen Dhan, to partially resign from her earlier statement before the IO, where she had stated that even when she informed her husband that Nasib Munda had sought sexual favor from her, her husband confronted Nasib. There was a quarrel between them. Nasib tried to assault her husband. Nasib is the deceased mother. Assault her husband Stephen with an axe, and Nasib crossed the single bamboo bridge and beat on the hand of Stephen. It is then that Stephen assaulted Nasib with bamboo stick. Nasib sustained injuries on the head and fell in the water. Both the accused person killed him by immersing Nasib in water again and again.
Where is that?
When the disease
Page
number 50, 55 and 56. Worship will kindly read from paragraph 32, my lord. 55,
paragraph
32.
32.
At page 55. The statement of PW4.
Yes.
Sabita Dhan.
That is again part of the.
Yes,
That's what she has stated.
No,
only.
it has been discussed, man. Nasib tried to assault her husband Stephen Dhan with axe, and Nasib crossed the single bamboo bridge and beat on the hand of Stephen. It is then Stephen assaulted Nasib with bamboo stick.
Where are you reading? Okay, you're reading that. Okay.
Man.
So the statement that she had made earlier.
Man.
It is the statement that she had made earlier.
Yes, yes. Then both the accused person killed him by immersing Nasib in water again and again. That was our statement. Even this court discards evidence of PW1 and 4. The evidence of PW2 remains intact. The defense not having been able to demolish the witness. Now, hostile witnesses. Lordship will come to paragraph 34. As narrated above, 56, page 56.
Yes.
As narrated above, PW1, who is a sister-in-law of both informant and deceased, and PW4, wife of accused Stephen and Stephen Dhan and relative of the deceased, have turned hostile. It is seen that PW4 retracted and declined, having told her husband about the so-and-so earlier, that on hearing the same, her husband confronted Nasib and quarrel ensued between Nasib and her husband accused Stephen, whether Nasib tried to assault Stephen with an axe. Then Nasib beat her husband Stephen on hand, and then her husband accused Stephen assaulted Nasib with bamboo stick. Then Nasib sustained injury on head. Nasib fell down into the water and accused Kishore Dhan killed him by drowning him into the water again and again. Then, in respect of the act of Nasib Munda, PW4 stated before the police that Nasib Munda caught hold of her and tried to lay her on a gunny bag. And when she tried to flee, her sister-in-law Astami tried to save her. Whereas before the court, she stated that Nasib asked her whether he could commit the act of sexual intercourse with her. Learned Constitutional contended that PW1 and 4 are hostile witnesses and therefore their evidence cannot be relied upon. Learned counsel for the defense further submitted that PW4, though portrayed as eyewitness by the prosecution, has only stated in the court that she had heard that Nasib Munda died, and hence the case of prosecution has no legs to stand. Now, the law with regard to evidence of hostile witnesses is well settled as held by the Honorable Court in so-and-so, to the effect that it is not correct to say when a witness is cross-examined by the party calling him, his evidence cannot be believed in part or disbelieved in part, but must be excluded from the consideration altogether. The correct rule is that either side may rely upon the evidence and that whole of the evidence so far as it affects both parties favorably and unfavorably must be considered for what it is worth. Again, in so-and-so, Honorable Supreme Court has held that evidence of hostile witnesses remain admissible evidence, as it is open to the court to rely upon dependable part of the evidence, which is found to be acceptable and duly corroborated by some other reliable evidences. Now, analyzing the evidence of PW1, the touchstone of the principle laid down in the case referred above, it is seen that the part of the evidence of PW1 to the effect that the accused person assaulted C, and C and PW2 went to ask him not to assault. However, the accused person chased them, is found to be acceptable. One part of the evidence is accepted by the court. PW10, Rajan so-and-so, brother of the deceased, also corroborated PW2 to the effect that it was PW2 Manimunda who had informed PW10, her husband, that both the accused person had assaulted him, because of which he died. On analyzing evidence of PW4, it is seen that PW4, before the court, truly stated about the sexual favor sought from her by Nasib, but went on to result from statement from the point her husband and brother-in-law came into the scene. The entire version of PW4 is found to be dependable. So the court finds that the entire version of PW4 is dependable and natural. And as such, Nasib, having attempted to take sexual favor from PW4, it was but nature for PW4 to resist and remind Nasib that she was the daughter-in-law and family to inform Stephen, her husband, about the act of Nasib when Stephen, her husband, returned from work. However, the motive reason of the quarrel that took place is seen, and reaction of the accused defendant is found to be natural. So, court considers it to be the mens rea for committing the offense.
So where is said that entire evidence of PW4 is dependable?
Page 58, para 43.
Para?
Para 43 of the judgment.
40, acceptable, it says acceptable.
Acceptable, 40, para 40,
Yes.
is found to be acceptable and duly corroborated by evidence in the court. So now the Honorable Court goes to say that Stephen, her husband, returned from work. Here the motive reason for the quarrel that took place is seen, and reaction of the accused Stephen is found to be natural. on the heat of the moment, he might have. Again, that PW4, wife of the accused defendant, subsequently resigned from her version of having seen her husband, accused defendant, and Kishore brother-in-law assault Nasib to his nature, in as much as realizing the consequence of the effect of statements of the accused defendant, she being the wife, would not want any harm to fall upon her husband. Again, this court takes judicial notice of the inspection memo on record in respect of accused defendant in the column owned on the body at the time of examination, so and so, it is recorded. Bite mark injury, Lordship will kindly note this. Bite mark injury 2 cm on the front side of the left forearm. This corroborates the version of PW4 that Nasib had bit the hand of the accused. My lord, it is a fact that the accused tried to assault, the disease tried to assault the accused, and he also bit the hand.
But where do you get this para 45 from?
45.
Again, this court takes judicial notice of the inspection memo on record. What is this inspection memo?
It would be the
In the
CD, Your Lordship.
CD, case diary may I see?
Wound on the body at the time of examination is recorded. Bite mark on the front side of
Yes,
the
it's there,
left
my lord, in the
forearm.
inspection memo.
This corroborates the version of PW4 that Nasim had bit the hand of the accused. That Nasim, that. Oh, so this is Nasim. This is the person, not a woman, who had bitten.
My lord, which
This corroborates the version of PW number 4 that Nasim had bit the hand of the accused. Nasim is one of the appellants, is it?
no, Nasib is the disease.
Deceased. So this version appears that Nasim had bit the
Lordship,
hand
but
of
in
the
the
accused.
inspection
But hand-
memo,
how
may
can
I?
it be had bit the hand of the accused?
Yes.
Accused is one of the appellants here.
Appellation.
So
So Nasib initially tried to attack him,
attack who?
attack the accused person.
Lordship, but in the inspection memo, I have just checked. Wound in body at the time of medical examination as regards Kishore Dhan, my lord. No any wound injury mark is seen in the body. It's there.
So now the court says, my lord,
As for
again, this-
Stephen Dhan is there.
no,
Stephen Dhan, Lordship, there are two inspection memo. One as regards Kishore, one as regards Stephen. As regards Stephen, my lord, in the inspection memo, it's there, column is there. Human bite mark, 2 cm. On the outer side of the left forearm, root of the body is okay. Rest of the body is
Of
okay.
whom?
Of this one, Stephen.
accused.
Stephen.
Yes,
Accused.
one of the accused person.
So, but where is the evidence?
PW4 says that was retracted statement, but it has been
No,
taken.
no, but
Lordship, from the
is
eyewitness
it in the
may I check?
evidence? There are CPW number 4's evidence. That is at page 14.
14.
Where does it say? That the deceased had bit Nasib. There is nothing.
Yes, it's there. Then Nasib bite on the hand of Stephen.
Where?
Lordship at page 15.
Page 15.
Yes.
Okay, in the
It is there.
in the retracted
Substantive
statement.
evidence, yes.
That has been taken into consideration, madam. So now it says again, paragraph 45, madam. Again, this court takes judicial notice of the inspection memo on record in respect of accused defendant, wherein the column owned in the body at the time of so and so is recorded bite mark injury 2 cm on the front side of the left forearm. So bite mark was there. So at least to that extent,
But why was the bite mark there?
because when he assaulted first, the deceased person.
Okay.
Then after,
But is it there in the inspection memo?
yes, it is there.
Lordship, But who has given that bite? That's not there. But as regards Stephen, it's there. Wound in body at the time of medical examination, because once the accused is
Okay.
produced,
Okay, then.
From PW4's evidence, my lord, it is clear that the bite mark was given by the disease. Other factor on record which corroborates the.
Okay, so now what do you want to say? What is your case? You see, as it is prima facie, this deceased had died due to the wounds inflicted on him by the appellants on being hit by a split bamboo. It is, you see, you all at page, I think in para 55, in page, in para 50, in para 50, the learned trial court has clarified the issue of that Assamese word. And you see, what led me up the wrong garden path was the fact that the word used was firewood. Now, firewood pertains to wood, but this was, I believe, a bamboo or a lathi, and it is a split bamboo.
Split bamboo.
Split bamboo.
Whether
So when you say torn firewood, that gives a totally different meaning. So I think this is a split bamboo.
Split bamboo, whether in.
So this disease was hit by a split bamboo.
Split bamboo, whether it is sufficient, that part of.
No,
course I
that
am not
is,
there, but,
why not?
Second, I am on the issue that, my lord, it is he, the disease. who
Maybe.
attacked
Maybe.
first. Then he may have exceeded the right of self-defense, but
So self-defense, will it be self-defense?
when he came with an axe and also
When he came with?
he came with an axe
Axe.
somewhere. Paragraph 35. 35 of the judgment. madam.
Paragraph 35. Yes.
That told the husband about retracted the decline, having told her husband about the act of Nasib Munda in trying to commit an act of sexual intercourse with her. That on hearing the same, her husband confronted Nasib and quarrel ensued between Nasib and her husband, accused Stephen. Whether Nasib tried to assault accused Stephen with an axe, then Nasib beat her husband, Stephen, on the hand. Her husband, accused Stephen, assaulted Nasib with a bamboo stick. Nasib sustained injury on head and Nasib fell down into the water, and accused Kishore and Stephen killed him by drowning into the water again and again.
You see,
So
according to
firstly-
this lady,
My lord.
BW4,
Yeah.
according to her knowledge, limited knowledge, death occurred due to drowning,
That occurred due to
according to her.
Yeah.
But the fact remains that she has also seen the deceased being assaulted
assault.
by a bamboo stick. So now the doctor is the best person to say
Say what is the reason?
what is the reason for the death.
Hmm.
Otherwise, next time I don't have to go to a doctor to, with my problems. I can go to this lady.
So my only defense is, my lord, now my.
So the thing is that the fact of the matter is that he was killed by a bamboo stick. The only thing is that whether there could have been some circumstances due to which the appellants had acted.
That's the,
That,
that's the thing.
and whether the sentence can be,
Yes,
can come down to
yes, yes.
under the
It
exception.
can be, yeah, yes. If the case can be brought in under general exception.
Under the general exception. That is that is what
That's
you're trying to
the-
do,
yes.
basically.
That is the only. Then my lord, it could not have been, the disease could not have been died in water because of the drowning or forcing by the accused. Because the body was found in the middle of the road, not in the drain. But it is also a fact that his thorax and everything was congested. by
That
mud.
is a different issue. You see, it doesn't mean
Death
that.
could not be death. Death could not be because of the drowning. In that event, the body would have been there only.
So, okay, now we leave that aside. The issue of death is clear. The reason for the death is clear. The fact that he was assaulted is clear. Now, the only thing that you are trying to prove is that this case comes within the exceptions provided under 300.
300. Because
So let's go to that issue straight away.
and my lord, only one aspect.
Page 88.
Page
exhibit
88,
seven
it
is
will
also-
also find it out.
Page
Our
88.
statement is exhibited. So with the
Sobita Khan is PW1,
Whose statement is this?
huh?
Sobita
PW4.
Statement.
exhibit 7.
Around 3 p.m. today, on so and so, my sister-in-law, younger sister of my husband, Srimati Astami Dhan and I were at home. At that time, our neighbor Nasib Munda entered our house and caught hold of me. After that, he spread a sack on the floor and forced me to lie on it. I tried to flee, but he stopped me by pulling my blouse. My sister-in-law Astami tried to prevent him, but he tried to commit a bad act on her also, and catching her hands, he told her to lie down. Bhoni tried to accept, but Nasib caught hold of her by grabbing her wearing apparel. Then Bhoni, my sister-in-law, attempted to escape. Nasib tried to catch hold of her. After some time, Nasib went to his house and came back by wearing a gamocha and tried to enter our house. Just at that time, my husband Stephen came home and I told him about Nasib. My husband asked Nasib about that, and on altercation ensued. While my husband Stephen was going for walk, Nasib tried to assault him with an axe. Nasib assaulted Stephen by crossing bamboo bridge. Nasib also beat Stephen's hand. As a result, Stephen became angry and assaulted Nasib with stick. This was a dry bamboo stick. Nasib sustained injury on his head and fell down. Thereafter, the Kiswah and Stephen killed him by drowning him into the water repeatedly. So that intention of to kill was not there.
Why not?
Because Lordship, he only tried to protect himself initially. Then, my lord, he might have fallen into the water, mud water, and thereafter he might have died. He might have exceeded the.
You see, you are harping so much on PW number 4. You forget about PW number 2. You're forgetting about PW number 2.
2 only goes to say that he was assaulted by the accused person.
And then she was assaulted also. She was pushed away
She was pushed away.
by this person. But the accused chased us, and as a result, we left the scene. Anyway, okay.
So my humble submission, my lord.
No
is-
intention to kill.
Well, So this may be a case of excessive, exceeding the.
You see, yeah, this is just loud thinking on my part. Your submission could have been plausible if the doctor had opined that he had died due to drowning.
That was not the opinion. But it is also a fact that he fell into the water, muddy water.
But he was drowned.
Doctor
Okay.
doesn't say that.
Okay,
Doctor
then what
says that
else?
it is-
What else? Anything else?
No, that is my.
Huh?
that
Anything
is
else?
my-
Nothing else?
That this may be a case of exceeding the right of self-defense, so it doesn't come. under-
Exceeding the right of self-defense.
No.
Can you show me? Can
At
you
the
show
heat
me
of the
any
moment-
citation?
My lord,
Exceeding the right of self-defense. That's a new one. Can you show me some citations?
Lordship will then have to, this is a very new subject for Lordship knows my, this is my first criminal matter, as I was asked by the Honorable.
No,
Court.
you see, yeah, the response has to be proportionate. If someone comes with you with a bamboo stick, you can't take out a double barrel shotgun in reply to it. The response has to be, quite proportionate.
Here it is other way around. The disease came with an axe, but
Acts.
he had a stick on his.
Was there any seizure made?
No,
nothing.
no, that is that.
No bamboo
I raised in the
seized,
very first
no
instance.
axe
No,
seized,
no
nothing.
seizure. That stick or bamboo stick or firewood, whatever.
How does that prejudice the case of the prosecution? If there is no seizure?
Whether if it is a stick, that may not have that impact.
If it's a bamboo?
Bamboo stick.
So let us go to 300 and the exceptions therein.
Either exception 1 or 4, Your Lordship.
I don't know, you tell us. The council, if the council is trying to bring it under those exceptions.
Yes, it might
Then he
be.
will have to show us under
Yes.
which exceptions it would come into, the case would come into. You cannot come with a problem and tell us, this is my problem, solve it. You have got to tell us which is the answer that you would like. And in support of your answer, and the answer you would like, you have to lead the way so that we follow you. You're going to be the shepherd. We are going to be the sheep. And of course, we're not going to be blindly following you in the biblical sense, but then we are going to be, a little bit cynical and have to be careful. But we have got to know the way that
Yes.
the council is trying to lead us.
Exception can happen.
Mark either this one or
Lordship will come to the exceptions of section 300.
Section
300.
Exceptions of
It has to be
section
criminal
300,
manual.
the third exception you mean?
No, I suggested either 1 or 4. He'll say, no?
You
The
suggest.
address.
The first person, provocation is not sought or voluntarily provoked by the offender as an excuse for killing.
Where are you reading?
Exception to section 300. Not homicide, not amounting to murder. Exception 1,
Yes,
when culpable homicide is not murder.
yes.
Culpable homicide is not murder if the offender, whilst deprived of the power of self-control by grave and sudden provocation. causes the date of the person who gave the provocation or causes the date of any other person by mistake or accident. The above exception is subject to the following provision. First, that the provocation is not sought or voluntarily provoked by the offender as an excuse for killing or doing harm to any person. Secondly, that the provocation is not given by anything done or in obedience of law or by public servant in the lawful exercise of powers. It is not that provocation is not given by anything done in the lawful exercise of right of private defense. This one and as well as first one.
So you see the words that you have got to use, you don't use the word self-defense. You have got to use the words private defense. And that this was due to sudden and grave provocation.
And
So you have got to
is-
harp on that.
provocation
Now, what
is
would be
not
sudden
by
and
me,
grave
but
provocation?
provocation, he tried to assault. That is the provocation with an
Tried
X.
to
No,
commit
Your Lordship,
rape.
not, I may be wrong, Your Lordship. Yes, he gave indecent proposal to the wife of the accused person, one of the accused person, that is the provocation. my
That was the
lord.
provocation.
And he tried to
initially, but
commit
He
rape.
did not act as it appears, my lord. Then he came with an axe and hit his head. That was the provocation. Enough.
No, one prudent person, if wife is somebody else's come and tries to commit rape, if he sees that, watch that, Your Lordship, generally
Okay, so
human.
what happens if that deceased had come and politely asked that PW4, can I have sexual relationship with you? Would that amount to rape?
No,
Would that amount to attempt to rape? So in this case, what does the evidence show? Was he trying to commit rape or was he asking for a sexual favor?
Proposal. He proposed
Proposed.
as it appears from the statement.
Then why this sudden reaction from either side, which ended in the killing of this
No,
person?
he somewhere said, description is there.
PW4.
When PW humanity person he all of position
Page 14. Evidence of PW 14, 4, my lord.
While my husband, my lord, you will see.
You see, because he went back to his house
Yes, again came
Again he came
wearing a
back.
towel.
and he came with the gamosha. He
Yes.
went, so you see,
But at that very moment, the husband came, the accused person. So she narrated the incident to the husband.
Where does he say that? She
It is
related
there in
the
the PW4 statement. Page
Yes,
14.
3 lines from the bottom at page
Bottom.
14.
He again came to our house by wearing a gamusa.
Okay,
At,
okay.
at that time, my
I
husband.
informed, yes, I informed.
Then, my lord, a quarrel took place between them.
Okay.
So that was the initial provocation. Then, when subsequently he came and attacked,
Some citations on grave and sudden provocation,
Lordship,
some
I am saying,
citations
yes.
on private defense. You are a senior counsel. We need you to teach us a little bit, and in turn, if we have something to share, we will
for
share.
other part, I have completed only the citation also will grant me some time because
Yes, madam, what is your case?
Yes, my case is, Your Lordship, PW 1 and 2, Your Lordship, they are the res gestae witnesses, my lord.
They are the
Res gestae witness as per section 6 of the Evidence Act. Your Lordship, may I take Your Lordship to the section 6, my lord? Relevancy of facts framing part of same transaction.
evidence.
Section 6.
yes.
Facts which, though not in issue, are so connected with a fact in issue as to form part of the same transaction are relevant whether they occurred at the same time and place or at different and places. Illustration, my note. A is accused of the murder of B by beating him. Whatever was said or done by A or B or by bystanders at the beating, also shortly before or after it, as to form part of the same transaction relevant fact. So these 1 and 2, although they say that they were not, they first of all they came, again they went back, and second time when they went there, they saw the accused, the victim to be there, your lordship. But since they are lordship, they would be taken to be a part of same transaction, as if they are the eyewitnesses.
Same transaction.
Yes. As because lordship at the relevant point of time, during the time when the deceased died, they might not be there, but immediately prior to that they were there. And when they came back, they saw the accused person.
Leaving aside the question of, the death being caused by the appellant.
Yes.
What do you have to say with regard to the submission made by him?
Yes, lordship.
That
If your lordship,
this act was done in private defense.
yes.
And that
sudden
this is due to grave and sudden
Yes.
provocation.
Lordship, if your lordship takes into account the evidence of PW4, who happens to be the wife of the accused,
Stephen.
one of the accused person, lordship, then your lordship, the case comes under general exception. My respectful submission is that it's your lordship to decide, lordship, as regards the quantum, my lord.
No, you see, but one problem that arises
Yes.
is that out here only Stephen is there.
No, and the drowning part, your lordship, he also there.
No.
Yes.
Just listen.
Yes.
So Stephen was the person who came in at the opportune moment and was informed about his behavior of the appellant.
Yes.
Deceased.
Yes.
Now, what about the other
Kishore
court
Dhan.
case?
Kishore Dhan.
Where
So
is
I
the-
was trying to.
Where is the sudden and grave provocation on the part of that Kishore Dhan?
But
And keep in mind the fact that, okay, Stephen started reacting, maybe, in private defense. But what was the role of Kishore Dhan?
yes, but he was also there at the place of occurrence.
Where?
Lordship, page
where?
8,
Who has stated that? Which evidence?
PW1.
PW1.
PW1, prosecution declared his violence of hostile. It is not a fact that I gave statement before police.
No, madam.
My lord.
I am not on you. I am
Yes.
on the. I am asking the counsel.
Yes, my lord.
This is Micus. If the appellants are taking the excuse of there being said grave and sudden provocation, and the fact that the act was done in private defense, how do you account for the action? That is with regard to Stephen, mind you. How do you account for the action of Kishore Dhan? What is he? Because
It's not
he
there, ma'am.
he is not there.
It's not
Then
there.
he comes and joins the fun.
I am representing.
Is it?
He joined hands in that drowning incident, my lord, in statement, but earlier to that, no such evidence is laying against him for any kind of a provocation thing, ma'am.
Correct.
I don't
He-
find, my lord.
he-
Being amicus,
yeah.
I fairly submit, my lord. I don't find anything.
That is what. So okay, even if we are to hold
Yes.
that there was some kind of grave and sudden provocation on the part of
That can be with Stephen.
on the part of the case Stephen.
Stephen.
We cannot say such thing with respect
No,
to
no,
Kishore.
because no such evidence is lying.
No such evidence is there,
No.
and it is not his wife also.
No. It is the PW4.
But Kishore Dhan is also, I think, related to.
Dear brothers.
Yes, but the evidence does no way show that he had suddenly come into the room together with Stephen and they were both informed. It is not their case.
But he was there as per evidence of PW1.
No, he was
accused
there
persons were
he was
there.
there at the time of beating up of the.
No, PW1, your lordship. Fourth line, no, that prosecution declared his witness hostile, she resigned from her so and so. Page 8.
Page 14, my lord, last 4 lines at that.
No, madam, I think you are misunderstanding.
No,
us.
your lordship, both of
No,
them
madam.
chased us.
I am in support of you.
Yes,
I am supporting your case.
yes.
With respect to Kishore Dhan. That's what
But
I'm trying to
both
say.
of them were there at the place of occurrence.
That much I know, madam.
Yes.
But okay, you answer us our question.
Yes.
What was the grave and sudden provocation on the part of Kishore Dan?
Yes, grave and sudden provocation, because if your lordship takes into account the relationship part of the.
But where is the
yes.
evidence, madam?
Evidence is not there, but if he is at the place of occurrence along with the other accused
Where does
person.
it show that she was at the place of occurrence
my
at the
lord.
time? No,
Both
please,
of-
please.
Yes.
Let me complete the
Yes,
sentence or the
yes.
question.
Yes,
Where do you see, at the time the wife of Stephen
yes,
had informed Stephen
Yes.
about what was happening and what the deceased had done to her. Where was Kishore Dan? Where is the evidence? Where was he? Did he join later on?
no. So I want to take your lordship to the evidence of PW1. When they first came in, these two accused persons were present. These two accused chased them, PW1 and 2. He was very much present. Page 8. Both of them chased us from the place of occurrence.
I don't know. I
No,
don't
no,
think
the specific overt act, your lordship.
Hmm?
That he was present, but specific overt act as regards drowning, that part is there. No other assault.
No,
Yes,
okay, so
Yes.
will the exceptions to section 300
yes.
apply to Kishore Dan?
Because they were
Lordship,
brothers.
because
were
relationship,
Now it seems
brothers.
both of you are.
No, no,
on the-
my lord.
I think you should also.
No, lordship, they were brothers. They
brothers.
were
were
brothers.
brothers.
Generally, if
No,
sister-in-law
you see,
is
I
attacked by
understand, but then
someone.
you see, we cannot go beyond the evidence.
Yes.
That is the problem.
Yes.
So basically, you are supporting his case that
No, my duty is to lordship to whatever is on the record to place it before his honor. Maybe it goes in favor of them, maybe it goes against us.
no,
my
so
lord.
that is the
Yes,
question.
yes.
You see, we cannot go beyond the evidence.
Yes,
The fact that this Kishore Dhan was also assaulting the deceased
yes,
is not questioned.
yes.
But what was the reason for Kishore Dan to suddenly assault this deceased due to grave and sudden provocation? That is the question. You
So
see?
may I submit my
Yes.
lord, my little understanding,
Yes.
lordship, because she happens to be the YPW4 happens to be the sister-in-law
Uh,
of the other accused person also, my
uh,
lord.
uh.
So as a reasonable person, if a woman or a sister-in-law is attacked or given indecent proposal, a reasonable person will behave in that way only. It might go against us, against the state, my lord, but my duty is to tell before you whatever my respectful submission is that, my lord. So it might be your lordship, he reacted in that manner and he helped the other accused person in drowning the deceased man.
Okay, let us take a scenario,
Yes,
a hypothetical scenario
my lord.
where there is a Mr. A and there is a Mr. B. There is they met somewhere and they had a fight for no
Yes,
apparent reason.
yes.
They had a fight. Mr. C, he comes, he's a brother of B. And he starts hitting A also.
Yes,
And A is killed,
yes,
supposedly.
yes,
Then what will be the if A once A is killed,
yes.
B and C are charged under section 302 and they are convicted.
So exception one,
Now, say B says there was a sudden grave and provocation with A because we were fighting. Then what will C's explanation be? Can he say that because A and B were fighting and because B is my brother, there was a sudden grave and provocation because both of them are fighting, so I came and joined the fight and I helped B.
there is no
assault.
explanation in 313. They did not give any such statement.
No, this is a
Yes,
hypothetical
yes, yes,
situation.
hypothetical question, my lord,
So similarly, in this case,
my lord.
you see, this Stephen had assaulted the deceased because the deceased first started the assault, and because of his actions,
That is the
Which was-
second provocation. First provocation.
which was informed
Right.
because of the happenings by his wife.
Right.
So Stephen accordingly reacted.
Yes,
Now, this Kishore according to both of you, he comes because he's angry.
Beyond the
That-
records, my lord. Yes.
So he's angry for what? Where is that evidence?
No, nothing is, nothing is.
That is
there.
what I'm trying to
Yes,
say.
my lord.
not there.
Yes, it's not
Because
there.
when we give our judgments,
Yes.
we have to give it based on
Yes.
facts and the evidence recorded. We cannot base it on speculations
Yes, my lord. There's nothing on
or
record.
suspicion. That is the
Nothing on
problem.
record. Nothing. on-
That's what I'm trying to say.
কিবা লিখিছে নেকি কিশোৰ? Lordship,
Just 1 minute.
yes.
We'll come back.
তাত কথাটো উল্টা হৈছে তোমাৰ বুজালে মানে ৰাইট অফ চেল্ফ ডিফেন্সটো যদি মই লওঁ তুমি কিন্তু নোপোৱা সেইটোৱে কৈ আছে
মই সেইকাৰণে কৈছো কাৰণ নহয় এটা কথা আছে আমাৰ society বয়সো বেয়া
এইটো হয় তুমি ঠিকেই কৈছা
মোৰতো এইটো নহয় যে মই বিচাৰৰ পৰা শিকিছো ৰোল অফ দ্য পিপল অবজেক্ট অল দ্য টাইম দেই কোৰ্টে ডিচাইড voice no objection dia mahal so boleh judgment dulu daftar itu bisa naik tapi itu lagi kita lihatin
Yes, anything?
Your Lordship, PW, evidence of PW 1 and 2. And the intention part, Your Lordship may culled out from evidence of PW 4, Your Lordship.
Actors Reus is there.
Yes. And Your Lordship, that I leave it to Your Lordship whether, if Your Lordship, whether the benefit be given to them or not. That I will not submit.
No, you should submit. We also want to know.
No, Your Lordship,
Yeah,
that's up to Your Lordship to decide.
No, we will decide, but it's your duty to submit.
Yes, my lord, my
And
duty
you
is
have
because
to also-
intention part.
You also have to give us some of your thoughts.
Yes, my lord.
So according to you, should the exceptions
Yes.
be
But
applicable?
yes, and the evidences says earlier the relationship amongst the deceased and
was very
accused were
good.
good.
There's
So
a
it
joke
is, it
and
may
all
be a
that.
case of grave and sudden provocation, my lord. And your lordship, so punishment part 304, part 2, my lord, it may be. Punishment for culpable homicide not amounting to murder. Second part. Second part, 10 years, my lord.
We'll see. Okay, I don't know. So that, so according to you,
If
they
your lordship takes into
they come
account
within the exception
general exception,
under section 300.
yes. Either 1 or 4, that will lordship will decide. Culpable homicide is not murder. Exception 4 says, if it is committed without premeditation in a sudden fight in the heat of passion.
But
upon a
we are
sudden
going to
quarrel.
record that,
Yes.
yes, that you agree that they come within the exception.
Yes,
Okay.
but your lordship, there are judgments. Even if the cases comes on a general exception, if the injury on the vital parts of the body, today unfortunately I could not bring that back. Whether all my citations are there, I'll give it by tomorrow morning. I'll give. So if it is on a vital part of the body, Supreme Court says that the benefit may not be given. But I leave it to your lordship, my lord.
So hitting on the head.
Head, it's on the vital part. So that your lordship will decide.
And even if it's drowning,
Yes.
then
No, not by drowning. Injury, your lordship, on the head.
I don't know. As
cranium.
per the submission of the
cranium, your
learned
lordship.
amicus.
Doctor's evidence. PW7's evidence.
That's all. Anything else?
That
So
much.
you just to give citation.
Yes.
Anybody else is there?
No.
No. Okay, right. Heard Mr. B. Taluga, Bija Taluga, learned senior counsel, who is appearing as an amicus curiae in this case, assisted by Miss.
I'm Mormon, my lord. I am for item number 4. That is another.
Oh,
Kishore.
yeah, for okay. Item.
That is
For
the
Kishore, she is appearing, but she is also assisting me.
separately.
Okay, we
Paper
no,
books are
just say
given separately.
amicus curiae. In which case are you there?
Same case for Kishore part, that paper book is given to me, my lord.
Okay.
For Stephen part,
In
the
41/2022, and Miss M. Burman, amicus curiae, in Criminal Appeal
40.
J 42/2022.
Lordship, may I add one more part? The non-recovery, non-seizure is not fatal for the prosecution case.
Citation?
Citations I'll give, my lord. 2017, tomorrow I'll give all the judgments in the morning.
Okay. Miss B. Buyan, senior counsel, assisted by Miss. Miss B. Boyan, additional PP, assisted by Mr. Jadas, appears for the state. Pusta. The two appeals have been filed against the impugned judgment and order dated 17 to 2022, passed by the Sessions Judge Dibrugarh in Sessions case number 399/2013, by which the appellants have been convicted under section 302/34 IPC and sentenced to undergo a rigorous imprisonment for life with a fine of rupees 3,000 each, in default, simple imprisonment for 1 month. The facts of the case in brief is that the PW number 3 submitted an FIR on 4/9/2013 at Chabwa Police Station stating that on 3/9/2013, at around 3:10 p.m., the appellants had chased Nasib Munda from his house with a lathi, L-A-T-H-I, lathi, bracket bamboo stick, and assaulted him, which resulted in the death of Nasib Munda. Next para. Consequent to the FIR, Chabwa PS case number 165/2013 was under sections 302/34 IPC was registered against the appellants. After investigation was concluded, charge sheet was submitted against the appellants as a prima facie case under section 302/34 IPC had been found against the appellants. The learned trial court framed the charge under section 302/34 IPC against the appellants, to which they pleaded not guilty and claimed trial. Next para. During the trial proceedings of the learned trial court, 14 prosecution witnesses were examined. Thereafter, examination of the appellants under section 313 just a minute. What is this in the it says 364-32235?
No, that's the earlier code. 364, earlier code.
In the paper book, it is said that.
It's same, my lord. It's written. If you want to.
Or they're using the old code.
Old code, my lord.
But what about 235?
Judgment of acquittal or conviction.
Huh?
Judgment of acquittal or conviction. কোথায় CRPC? গড় এটা 230 নতুন
Where is the 313 statement of this Stephen?
Stephen, it's on record, my lord. It's not given in a paper book. It's there.
Not in the paper book.
Stephen, make sure this. Section 3, lordship, it's there.
Which page?
Page 2, 31. Page 31.
31 is Kishore Dhan. Where is Stephen?
Stephen, my lord. Paper book no idea, no? It's on record, my lord. Stephen, my lord.
Yes, Stephen.
it's there.
It is there.
It's in English, my lord.
Okay, so what have I said?
Did you?
Of the appellants, appellants under section 3 and 313 CRPC was undertaken. Full stop. Subsequent to the above, the learned trial court came to a finding that the appellants were guilty of the offense under section 302/34 IPC, and by the impugned judgment and order dated 7/2/2022 convicted the appellants under section 302/34 IPC. Sentence was accordingly imposed upon them on the same date as stated earlier, as stated in the earlier paragraphs. The learned amicus curiae in both the appeals submit that though the evidence of PW number 2 clearly shows that shows that the deceased had the deceased was assaulted there is nothing to show that the deceased had died due to the assault. They also submit that PW number 1 and PW number 3 had been declared hostile witnesses.
1 and 4.
1 and 4 had been declared hostile witnesses by the prosecution. However, a reading of the statement made by PW number 4 to the police under section 161 CRPC read with what have I said? The last. Read with para 45. No, read with para 44 and 45 of the impugned judgment and order would go to show that the action of the appellants in assaulting the deceased was not only due to grave and sudden provocation on the part of the deceased in trying to have sexual relations with the wife of the appellant bracket Stephen Dunn, DHAN, Stephen Dunn, comma, but also due to the appellant having tried to assault the appellant Stephen Dunn with an axe. Which required the appellants to exercise their right of private defense. The learned amicus curiae thus submit. No, the learned amicus curiae next para also submit that there was no intention on the part of the appellants to kill the deceased. They submit that as the case comes within the exceptions provided under section 300 IPC, comma, the impugned judgment and order and sentence should be set aside. And the sentence and the petitioner and the appellants be convicted and the appellants be sentenced under part 2 of section 304 IPC. Correct? That's all? Anything else? Next, Miss B. Boyan, the additional PP submits that it appears that the exceptions under Article 300 IPC can be applied to the case of the appellants.
Section 3.
Section 3.
Huh?
Section 3.
Or section, what is that?
Article, because Lordship, most of the times.
The
WPC
report.
That is
repetition.
the difficulty with me also.
Okay. In view of the trial court having taken judicial notice of the inspection memo on record, where the bite mark on the left forearm of the appellant Stephen Dunn is recorded, and which is in consonance with the statement given by PW number 4 to the police under section 161 CRPC. The learned additional PP submits that the answer given by the appellant Kishore Dhan to question number 5 during his examination under section 313 CRPC would also corroborate the statement made by PW number 4 under section 161 CRPC. As it appears from the evidence that the deceased was trying to have sexual relation with the wife of the appellant Stephen Dunn, and which was informed to Stephen Dunn when he suddenly entered his own home, wherein the deceased was present, the fact of grave and sudden provocation appears to be quite plausible in the facts and circumstances of the case. That's all. Anything else, madam?
That will do, my lord. In our substantive evidence also she says, whatever she has stated before the police also, in her substantive evidence before the court also says told about the bite marks and all, my lord, PW4.
No, she has not stated that. She has denied stating that.
Is 15, my lord?
Yeah.
15?
Yeah.
Then Nasi bite on the hand of Stephen.
Yes, you see, this
Yes.
thing is you
Yes.
come to, it is a denial. It is not a fact that I gave the statement before the
But there's a
police.
full stop, my lord.
You come to page 14, madam. This is in italics. You come
Yeah,
to
yes,
page
yes.
14.
I'm sorry. Yes, yes.
This entire thing
Yes,
has
yes,
been. So this is denial. Actually, now the question actually is, what is the witness reliable? Can her statement be, does it inspire the confidence of the court?
Lordship, then
When
the
you get-
evidence of PW 1 and 2 would come. 1 and 2. If your lordship leaves aside the evidence of PW4 because she was declared hostile, if this one witness is declared hostile, an independent witness has to support, because this cross-examination is done by the prosecution side. Our own witness will cross-examine. So it has to be supported by an independent witness, my lord. But it's on record, it's not there. So evidence of PW 1 and 2 would come into force, my lord. PW 1 and 2, they were part of same transaction. They saw the accused person present at the place of occurrence, and immediately thereafter,
So, madam, there is one issue here.
my lord.
If we had to discard the evidence of PW4,
My lord,
and where is the question of grave and sudden provocation?
that is there. That is there. That is there.
Her
Lordship.
statement, which
Huh?
was her statement is page 88,
88.
which was exhibited as Exhibit 7.
Still then, any statement made to police, my lord, even if it is exhibited, your lordship.
It is made to the police, now she denies it.
Yes. Yes, ma'am, she denies it.
Then what is the value
So if
of
you're, yes,
what is the value of a retracted deposition? I mean, retracted statement. What is
so she is declared hostile, whatever she has stated, yes.
No, so I'm asking a question of
So,
law.
so your lordship, her evidence would have no value. Entirely it would not go. In toto, it not go if it is supports by any other independent witness. But in the instant case, I did not find any of the witnesses, my lord, who supports that part of the prosecution. But there, the evidence of PW 1 and 2 remains, my lord. It's remain unshaken. PW, especially evidence of PW 2.
Correct. In that case,
So advantage, so I left it to your lordship, my lord, to decide, lordship, about whatever lordship will decide.
no,
my
you
lord.
see, we have got to be very clear here. We have got
My
to know
lord.
the law.
My lord,
What happens when a witness
Yes.
retracts her statement,
yes,
which has in the court,
yes.
but which has been made to the police? What happens there?
Statement to police is
Can
not
the statement
admissible.
is not admissible?
No.
If a statement
So
to police
unless
is
the
not
court
ac-
permits, my lord,
is not acceptable, then what to do with this? So can we go into whether the exceptions would apply?
No,
Because this is the only.
that the judgment of the court below, my lord, it had relied one part of the statement and it had. Also, will see that I read it earlier from paragraph 38 onwards. It had relied one part of the statement and it had discarded the other part. Whether relying on one accused that can be relied on the other part.
What about? So you have to tell me. You have to show us the
lordship
law.
may,
Therefore-
in appellate stage also, your lordship may appreciate and reappreciate whatever was.
No, we want to
Yes,
reappreciate.
Yes,
But we
reappreciate.
want
So
to
he
appreciate
wanted to
correctly.
rely upon, but your lordship, if even if your lordship, if your lordship wants to come to a finding, if it goes in favor, then that person, that
You see,
the
madam,
advantage is still.
we have got to pass an order,
Yes,
which is a reasoned order,
yes,
which is based on reason.
my lord.
Now, it is not what we wish to do, but what should have been done, and as
If
per the law.
you're, yes,
So we want the help of citations.
yes, yes. So
If it is there.
lordship,
So-
can it be taken up tomorrow, then let
My
the,
lord,
yes, let
one
it
more
be
thing,
remain as
madam.
part heard.
The court below, my lord, took the evidence, accepted the evidence in one part, that the mens rea
No,
is
no,
because
I mean,
of, no, lordship,
yes,
let me submit, my lord. The mens rea is because of that sexual advancement. That mens rea is taken as a lordship will see at paragraph 43. Then it is also a fact, there was a bite mark in the hand of the accused. So it corroborates the statement of PW4 that he had the disease that.
What is the law? What is the law laid down by the apex court with regard to
Hostile.
the statement made to a police officer and who has been declared hostile by the court?
So, Your Lordship, it has to be supported by an independent witness. If the person is declared hostile, so our witness becomes hostile, we do this one, cross-examination. Our witness we cross-examine. So it has to be supported by an independent witness, my lord.
Then-
Lordship, then from the independent witness, it will come, Lordship. If it comes in evidence, my lord, which supports the prosecution case, then Your Lordship may rely upon.
And my submission is very presence of the bite mark, my lord, goes to corroborate the statement of PW4.
Now, there is another aspect. Can judicial notice of an inspection memo be taken,
Yes.
which does not form a part of the charge sheet? Is it a part of the charge sheet?
I don't think so.
And which is not exhibited?
No.
Whether the contents of an unexhibited document,
Cannot be.
is it admissible as evidence?
No,
Huh?
no, cannot.
Then where is the question of the exceptions being made applicable?
Yes. Yes, Your Lordship. Then the evidence of PW1 will and
So you see, when you come to this court, you have got to, which has also,
My lord, again, I take your lordship's paragraph 45.
it has to be a two-way experience. If it is an unexhibited document,
it cannot be.
can it be admissible as evidence? Can the contents be admissible as evidence? What is the value of a judicial notice? Can judicial notice be taken of an
Non-exhibited.
unexhibited document? I mean, I don't understand.
Other day before just prior to vacation, court number 6, we did a matter. It was an unexhibited one. Lordship, it's not admissible.
And then where's the question of this aspect of the matter being considered by this court?
Yes. So I said, Your Lordship may reappreciate whatever.
And
Yes.
we will appreciate,
Yes.
but please
Lordship,
guide
then
us.
Lordship, let the matter be taken up tomorrow. We'll
We
come
have
with
got two
citations.
senior advocates in front of us. You have to guide us.
Lordship. Tomorrow, then, my lord, as a part heard matter, immediately after the part 1. Next week, bench na kare. We'll come up with citations.
You see, specifically on 2 points.
Yes.
The first point is,
Yes.
can a document which is not exhibited,
Yes.
is it admissible in evidence?
Yes.
Number 2 is whether a document which has not been exhibited in evidence can be admissible as evidence if judicial notice is taken by the
Yes.
court.
Yes. Then the other part, hostile witness.
Now, then the other thing is that you see whether the statement given by a prosecution witness under 161 CRPC is admissible in evidence if the witness is declared hostile. So where were we?
Tomorrow.
That is her submission, no? Oh, sorry. Okay, just write, you type it out separately and you give it to me. Don't put it in the order, huh? All right. after he heard so, all of them you write, and they say, this is the matter, this is the matter tomorrow as part of.
Yes.
Tomorrow,
Tomorrow,
any day my next week.
next week,
Any day.
next week. This is the matter on when? I think Monday we've already fixed that batch matter with Madam Nandi. I think I think better not to put partner, otherwise different will happen. I don't know who are the sitting with next week. No? This is the matter on
Any day.
when do you want?
I want tomorrow only.
He is not ready. Will you be ready?
Any day, Lordship, I will. Not tomorrow because he'll.
Not tomorrow. You see, Monday we've got a batch that matters there. The question of law matters there. So Tuesday?
Tuesday.
Tuesday. On 23rd then, my lord, 23rd.
Huh?
23rd, your lordship.
23rd. Just put down the thing I've just told them to make. The number one. Number one is, what did I say? Number one, please read out. Those three things you are supposed to find out.
Whether unexhibited document is admissible.
Whether unexhibited documents are admissible in evidence.
Yes.
Number two,
Lordship, if it is an unexhibited document, but judicial notice is taken by the court below.
unexhibited document, whether an unexhibited document, comma, which on which judicial notice has been taken by the court is admissible in evidence. And number three, madam, what was it?
Lordship, whether a statement made to the police,
Whether statement made to the police under section
161
161
CRPC,
is admissible as evidence
when the
when the said witness has been declared a
Hostile.
hostile witness. Just put this.
May it please your lordship.
Item 8.
My lord.
That is the item 8. Yes.
Here the appellant before the lordship's my lord stands convicted under section 302 of Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment for life. And then the default clause is also there. He has been also directed to impose a fine.
Let us go to the FIR.
My lord, lordship will find the FIR at page, my lord, with all respect. Yes, 4, my lord.
Yes.
May I read, my lord?
Yes.
Humble submission is that around 3:30 p.m. today, that is on 5/9/10, when my husband Sri Nonodas was going to a shop in the village from our house on foot, Sri Moinadas, son of so-and-so of the same village, waylaid him on the road without any reason and caused severe injuries to my husband by hacking him on the chest and neck with a dao with an intention killing him. Then being smeared with blood, my husband fell on the road, and finding him in a critical condition, we took him to hospital by 108 ambulance service and got him admitted there, but around 7 p.m. he succumbed to his injuries in Konoklota Civil Hospital while he was undergoing treatment there. I therefore pray to you to take necessary steps against accused Moinadas by investigating into the matter and oblige. This is the FIR lodged by the wife of the deceased, my lord.
Let us see the evidence.
My lord, lordship will find her evidence at page, my lord, page 10, my lord, PW1. May I submit one thing, my lord? In the FIR, my lord, nobody has been named as an eyewitness, my lord. No name of eyewitness is.
How does it matter?
My lord, because 3 and 5, my lord.
How does it matter? Where does it say that just because you're not named as an eyewitness in the FIR, that you cannot be, that there cannot be an eyewitness? Where does it say that?
My lord,
Somebody could be in some field, somebody you might not know
My
that
lord.
person. There could be a stranger who had eyewitnessed them.
My understanding, my lord.
Yeah, so,
PW1 is the informant, my lord.
yeah.
I know accused Moina Das. This is Naina Das was my husband. Around 3 p.m. about 4 years ago, I went to the nearby shop. I went to a grocery shop. My daughter Deepamani Das came at a run and told me that accused Moina Das had cut her father. Then I came running and saw my husband lying under the tree at the gateway of my house. I saw cut injuries on the neck, chest and hands of my husband while returning from shop. As I was about to reach my husband, I from a distance of about 10 meters saw he was running away with a dao in his hand. When I reached my husband, two persons, namely Mundas and Krishnadas, were helping my husband drink water. And a neighbor came and called a 108 ambulance. An ambulance came and took him to Konaklata Civil Hospital, Tezpur. My husband died at the hospital around 5-10 minutes after he had been taken to that hospital. Then I lodged a written Ejahar with Bebeji outpost. I lodged the Ejahar around 8 p.m. On the day of occurrence itself, a person wrote the Ejahar on my behalf. I put my thumb impression in the Ejahar after it was written as per my version and was read over to me. I put my thumb impression in the inquest while police held inquest on the body of the deceased. Now, this is cross part, my lord. Police came to my house, that is the place of occurrence, around 3 p.m. the following day of the incident. My husband was lying in injured state under a banyan tree at the gateway of my house. The distance between my house and banyan tree is about 550 meters. Police examined the place in which my husband was lying. I was there during the inspection of the place. There were grass and stones at the place where my husband was lying. Police did not seize anything from the place of occurrence. The distance between banyan tree and the shop where I went is about 50 meters. My daughter Deepamani is 10 years old. She informed me about the incident. The name of shopkeeper is Baba Soikya. He did not come to the place of occurrence. First, I met Munu Das and Krishna Das, and the other people came later. When I arrived near my husband, he told me on the road that Moina, I will die. There was no other person near me when my husband told this to me. It is not a fact that I did not see the accused running away with a dao in his hand. The old house of accused is about half a mile away from the place of occurrence. I got the Ejahar written at the PS itself. Police personnel were there at the PS. I went to the shop by the side of the banyan tree. At that time, there was no one under the banyan tree. It is not a fact that I stated that my daughter had informed me when I was at the shop itself. Now a court question, my lord. When did your daughter inform you about the occurrence? When you were inside the shop or when you came out of the shop? My daughter informed me when I just came out from the shop. Next is PW2, my lord. He happens to be the son of the deceased, my lord. I know the accused present in the dock. Informant Maina Das is my mother. This is Nono Das was my father. The occurrence took place in 2010. On that day, I went to Bindukuri market. Around 5 p.m., I returned home from the market. I saw my father lying under a banyan tree in an injured condition. I saw cut injuries on the neck and chest of my father. He was lying in a pool of blood. On being asked, my mother told that accused Moina Das had cut my father and fled. My father said to me, Moina has cut me and fled. What are you doing? Then I called an ambulance. When the ambulance came, we took my father to Konaklata Civil Hospital. My father died in the hospital in the evening. Police came to the hospital and held inquest on the dead body of my father. I put my thumb impression in the inquest report as witness. My mother was also in the hospital. My mother lost the written Ejahar with the PS. First part, my lord. Police interrogated me in connection with the occurrence. I did not state before police that I had returned from market around 5 p.m. I did not witness the occurrence. I did not see how he had sustained injuries. I did not see the dao being seized by the police. The accused got married to my sister's daughter. It is not a fact that Moina Das lost several cases against our family earlier. Witness Fuleshwari Das is my Borma. and witness Bokuli Das is my grandmother. I regard Upen Das as my daughter, father's elder brother, but he is my own daughter. It is not a fact that prior to the occurrence, I assaulted the accused and fractured his head. It is not a fact that I assaulted the accused with lathi, thereby causing grievous injury to him. We have good rapport with the witnesses of this case. When my father was lying under the banyan tree, there was no one except my mother. There are 5 other houses near our house. The residence of Sondas is situated near the place of occurrence. There are 5 members in Sondas's family. 4 among them are adults and 1 is minor. The place of occurrence is situated near the PW road. People always use that road. All the people of our village knew my father. I do not know at what time the occurrence took place. I saw it after returning from the market. Police did not seize the blood-stained clothes. I do not know if the dao was seized. I do not know about the seized items. It is not a fact that after returning from Bindukuri market at about 5 p.m., I did not see my father lying in injured condition. It is not a fact that father did not tell me that accused has cut him. It is not a fact that no ambulance came. It is not a fact that we lost this case against Moinadas on false grounds owing to our old grudge against him. This is PW2. He also did not see the incident, my lord, as per him. PW3, my lord. He sees Fuleshwari Das, my lord. I know the accused present in the dock. I know the informant. I knew this is Nena Das. He was the husband of informant Maina Das. Around 3 p.m., some 5 years ago from today, when I was coming back home after teetering goat, I saw accused hacking Nena Das with a dao on the road of village Bahbari. I saw him hacking on his chest, neck and hand. When Nena Das asked for water, I went home running, brought water and poured the water on the head of Nena Das. This part of evidence, my lord, possibly, this part of evidence, if Lordship reads PW1, this if Lordship goes back to PW1, that she brought water and poured upon the head of the deceased, my lord. That is not in the evidence of PW1. PW1 says
how does anyone know what others are doing?
No, my lord. According to her, when she witnessed the occurrence, immediately she came, she poured water on the
Who
deceased.
witnessed the occurrence?
This PW3.
PW3 witness, yes.
She says she has seen the occurrence.
Yes.
I saw the accused hacking Nena Das with a dao on the road of village Bahabari. I saw him hacking on the chest, neck and hand. When Nena Das asked for water, I went home running, brought water and poured the water on the head of Nena Das.
Correct. So what is wrong?
PW1 says, my lord, it was not PW3 who provided water to the deceased, but two other persons, my lord.
How does it matter?
Well, because she was not even present. That is why I'm submitting.
You're saying that this number 3 was not present.
Yes, my lord. PW1 says, my lord. That is my submission, my lord.
I know.
Yes.
So we're recording.
PW1 says, my lord, Mundas and Krishnadas was helping my husband drink water. She even does not name PW3.
Yes, but you see, drink water and pouring water over the head is different.
But her presence...
Out here, this PW number 3 does not say that he gave water to Nena Das to drink.
My lord.
He gave what he poured water over his head.
So
where is the contradiction?
My lord.
PW1 says...
PW1 does not say about PW3 being present there.
You can't talk about everybody. How does that matter? No one's like a computer. He's there. Her husband is there bleeding, going to die.
I understand, my lord. But PW3 1 does not say presence of PW3 at the place of occurrence. That is my submission.
PW
1 does not say presence of PW3 at the place of occurrence.
Okay.
May I continue, my lord? Last part of page 16, my lord. I went home running, brought water and poured water on the head of Nenadas. Nenadas sustained injuries and was bleeding. I left Nenadas and went to inform his wife. Whereas PW1 says, my lord, it was her daughter who has informed her regarding that.
You see, it will not only be her daughter, there'll be maybe another 20 persons who will go and inform the wife.
But the daughter has not been examined, my lord.
Huh?
Daughter has not been examined in this case.
Whose daughter?
The informant's daughter.
He has been examined. PW2 is the daughter.
No, he happens to be the son, my lord.
Huh?
PW2 happens to be the son of the deceased, my lord.
How does that matter? You're just beating around the bush.
PW1 says, my lord, with all respect, my lord, she was informed by her daughter, my lord, regarding the assault made upon her husband.
Correct.
But PW3 says, my lord, that she went to inform the informant.
But did she say that she informed the PW1? She said that she went to inform. She
Yes,
doesn't
my
say that she informed. So where's the contradiction? Supposing something bad happens to somebody, I'm quite sure if there are 20 persons there and if 10 of them know, all 10 of them will try and tell that person, the relative of whatever. It is not that only one person will say, out of us, you are the person to go and say. Nothing like that.
And she is 10 years old, my lord. She's only 10, child witness.
Anyway.
Maybe.
Maybe. Then
I left Nenadas there and went to inform his wife. Nenadas's wife came to the place of occurrence. Thereafter, Nenadas was taken to civil hospital for treatment and he died there. Today, I have seen a dowry at the court, but I am not able to recognize if it is the said dowry or not. But I saw the incident of hacking. Police interrogated me about the occurrence. The house of Nenadas is almost adjacent to my house, and there is just one house in between the houses. It is not a fact that I told the police that Nenadas has assaulted Moinadas with a lathi. It is not a fact that a scuffle broke out between them. I do not have any dispute with anyone. I have not been able to recognize some part omitted, which I have seen in the court today. It is not a fact that I did not state before police that on being informed by me, Nenadas's wife came to the place of occurrence. I saw the incident from a distance of 200 meters from the place of occurrence. There were small trees in between and the trees were taller than me. It is not a fact that I did not see Nenadas hacking Moinadas. It is not a fact that I did not witness the occurrence. It is not a fact that I have adduced false evidence. Yes, Nenadas was my neighbor. It is not a fact that Nenadas's house is not visible from my house. This much, my lord. Now PW4, my lord. There is a doctor, my lord. On 6/9/2010, I was working at KCH Tezpur. On that day, in reference to Tezpur PS case number so-and-so, I conducted post-mortem examination on the dead body of Nenadas. So-and-so. Dead body was brought and identified by Constable so-and-so. External appearance, a male dead body was seen lying on top of post-mortem table, wearing a black long pant and check brown underwear. Eyes and mouth were half open. Rigor mortis was present. There was a cut injury of about 2.5 inch into 1 on left side of neck, cutting the left sternomastoid and carotid artery. There was cut injury on the left side of chest, cutting left first and second space. Semen was present. Facial matter was present. Cranium and spinal canal healthy. Now thorax, there was also injury. Left first and second place was cut, including the pectorals major muscle. Pleura was cut beneath second space with hemathorax on left side. Larynx and trachea healthy, right lung healthy, left lung cut in upper lobe, pericardium healthy, heart empty, vessels healthy, abdomen, my lord, there was no injury in the abdomen. The cut injuries were antemortem in nature, my lord. Now, in my opinion, Nenadas died of exudation due to cut injury of left carotid. Exhibit 1 postmortem report, exhibit 1 2 is my signature. Now PW5, my lord. I know the accused in the dock. His name is Moinadas. I also know the complainant. This is Nenadas was my nephew. The occurrence took place about 6-7 years back. The occurrence took place on the road in front of my house. There was altercation between the deceased and the accused. I saw the accused Moina Das assaulted the deceased Nana Das with a sharp cutting weapon. I saw cut injury on the chest of the deceased Nana Das. Nana Das was taken to hospital in injured condition, but he died in the hospital. Police came and arrested accused Moina Das. Presently, I am having problem with my eyesight. At the time of occurrence also, my eyesight was poor. The occurrence took place on the road in front of a gate just beyond the gate of my house. I did not see when the blow was inflicted on Nana Das, but I saw that the deceased fell on the ground, and coming near the deceased, I found that blood was coming from his body. Police recorded my statement. It is not a fact that I did not state before police that I did not see Nana Das falling on the ground. It is not a fact that I did not state before police that coming near Nana Das, I saw blood coming out from his body. Accused is my grandson. It is not a fact that I did not see the occurrence. It is not a fact that in the interest of my nephew, I have given false evidence. Now, my lord, PW 6. Accused is my son. I know the complainant. I also knew the deceased. The occurrence took place 5 years back. On the date of occurrence at about 5 p.m., I came back home from Bazaar. I heard that there was a quarrel between Nana and Moina Das. I also heard that Nana died in the hospital. Police obtained my signature in blank sheets. Exhibit 2 scissor list. Exhibit 1 is my signature. I live in separate house, about 1 kilometer from the house of Moina Das. He was declared hostile also. So he actually produced the DAO, my lord. Unless to have been involved.
He was a Caesar witness.
Mine. Now, prosecution has cross-examined him, my lord, after declaring him hostile. It is not a fact that, as stated before police, Bebesia police asked search for the DAO by which Moina Das killed Nana Das. Then I went to the house of Moina Das, and on charge I found the DAO and identified the DAO as being used by Moina Das to kill Nana Das. Police seized the DAO in presence of one Upen Das. I also put my signature in the scissor list. It is not a fact that today I have suppressed the fact regarding the recovery of the DAO from the house of Moina Das to save Moina Das, my son. Now, crossed by defense partner. Police did not record my statement in connection with the case. I did not state before police that I found the DAO used by Moina Das and identified the same as being used by Moina Das in killing Nana Das. Nor I handed over the DAO to police. Police obtained my signature in the scissor list about 3 weeks after the occurrence. The incident took place on 9/5, my lord. Seizure was made on, with all respect, my lord, after 3 weeks. The PW 7 is the IO, my lord. On 3/10/10, while I was serving as in charge of Bebesia outpost under Tezpur, I received the case diary in connection with so and so, so and so. On receipt of perusal of the case diary, it was found that already SI so and so visited the PO, recorded the statement of witnesses, held inquest on the dead body, and took step for post-mortem examination of the dead body, and seized one DAO from the house of the accused. I only collected post-mortem report from hospital, and on completion of investigation, I submitted charge sheet against accused so and so under section 326, 307, and 302. Exhibit 3 is the charge sheet. Now, cross part, my lord, I did not visit the PO, I did not record the statement of witnesses, nor I seized the weapon of offense without properly going through the materials on record. I submitted charge sheet against the accused. Now, PW 7 was again examined possibly, my lord. I know Puspendra Medi, who was serving as in charge of Bebesia outpost under Tezpur police station. The said Puspendra Medi had expired on so and so. This is Puspendra Medi was the erstwhile investigating officer in connection with Tezpur PS case number so and so. As per the case diary, it appears that during investigation, Puspendra Medi conducted the inquest over the dead body of the deceased and also prepared inquest report. Exhibit 4 is the inquest, and Exhibit 4.1 is my signature of Puspendra Medi, which I know. I also prepared dead body Salan Exhibit 5. In his 5.1 is his signature, which I know. It also appears from the case diary that he also sees the carved out during investigation by Cisalis, which is Exhibit 2 and 2.2 is his signature. I know on 5/9/10, written FIR was received by IC of Bebesia OP, whereupon GDN 74 dated 5/10 5/9/2010 of Babesia OP was made and later Tezpur PS case number so and so was also registered and Pushpendra Medhi was entrusted with the investigation of this case, which is clear from the entries in the diary. Exhibit 6 is the FIR, Exhibit 6(1) is the signature of Pushpendra Medhi, and Exhibit 6(2) is the signature of OC Tezpur PS, namely Tapos Chakraborty. PW6, Someshwar Das stated to police that Babesia police asked search for the dhow by which Moina Das killed Nano Das. Then I went to the house of Moina Das and on search I found the dhow and identified the dhow as being used by Moina Das to kill Nano Das. Police seized the dhow in presence of one Upen Das. I also put my signature in the seizure list. Now crossed again by defense panel. The affair was received on 5/9/10 at 8:30 p.m. Pushpendra Medhi had recorded the statement of 4 witnesses, Fuleshwari Das, Bokuli Das, Suta Das, and Moina Das. Seizure witness Upen Das and Someshwar Das were examined on 7/9/10. Mundas, Krishna Das, and Deepamani Das, who is the daughter of the informant, were not examined in this case. Exhibit 2 specifies that the carved dhow was produced by Someshwar Das and it was accordingly seized. PW3, Fuleshwari Das did not state to police that she had given information to the wife of Nono Das and accordingly she came to the place of occurrence. It is not a fact that PW6 Someshwar Das did not give any statement before the police as I have stated above. I submitted the charge sheet on the basis of the materials collected and the documents annexed with the case diary by the previous IO. There is nothing in the case diary to show that the carved dhow which was seized during investigation was sent to FSL for chemical examination. It is not a fact that the previous investigating officer did not conduct the investigation of the case properly, and based on the materials collected on faulty investigation, I submitted the charge sheet against the Landed court below, Landed court below relied upon primarily PW3 and 5 to base the conviction in the judgment that if lordship will find it page 39 para 26, 27 and 28.
Yes.
Primarily on PW3 and 5
Yes.
court below, page 39 para 26, 27 and 28. Considering PW3 and 5 to be eyewitnesses of the alleged occurrence.
Yes.
Now, my submission is this: if a co-joint reading of the evidence of PW1, 3 and 5 is done, in my humble understanding, possibly 3 and 5 cannot be eyewitnesses of the occurrence because of the fact that
In view of the evidence of P1, PW1.
if it is written in together, PW1, 3, PW3 and PW5,
In view of the evidence of PW1, PW3 could not have been an eyewitness. What about 5?
5 also, because PW5 she says that her eyesight was poor.
Eyesight was poor meaning what? Is it for purpose of reading or for looking at far objects? You see, for example, my eyesight is very good for driving, for doing everything. But for reading, I need glasses. So, what do you mean by poor eyesight?
I understand. But then also, PW5 says, immediately after the assault, seeing the assault, my lord, she went there, saw that this is lying in a pool of blood, my lord. And regarding her presence or arrival at the place of occurrence, it is neither stated by PW1 or PW3. My lord. That is why, my lord, I earlier, my lord, made a mention that, my lord, no name of eyewitnesses appears in the FIR, my lord. That is why I possibly, my lord, in my humble understanding, my lord. So in my submission, my lord, humble understanding, my lord, 3 and 5 cannot be eyewitnesses. PW5 also says that, my lord, the incident took place in front of her house. But if lordship, my lord, that is my submission, my lord, here uses the sketch map, my lord.
Any citations
My lord, regarding, my lord,
regarding that if the eyewitnesses who come forward are not mentioned in the FIR, their evidence cannot be considered or are not admissible as evidence?
My
Is
lord.
there, or is that a law made up by you?
No, my lord, I am not, I cannot make that law, lordship.
So, no,
made
so
it,
what
my
is the law?
No,
You
my lord.
please tell us the law.
No, my lord. It is incident occurred at 3 p.m. my lord,
3 p.m. in the afternoon.
in the afternoon. My lord. FIR lodged at 8:30 p.m. 8:30 p.m. my lord, and the same day, my lord. All these people are from the neighboring area, my lord.
Correct.
So
Correct.
had these people had witnessed the occurrence, because PW2-1 admittedly did not see the occurrence, my lord. She was, according to PW2, reported by her daughter, Deepamani, as at about 10 years, my lord. Now PW3 says that, my lord, she has informed the informant. So if, my lord, these witnesses were very much available at the place of occurrence, my lord. So that is why, my lord, it assumes possibly significance regarding non-mentioning of their names in the FIR, my lord. In my humble understanding.
Show us the law.
My lord.
If you see, if you go only by your humble understanding and we go by our humble understanding and she goes by her own humble understanding,
my lord.
then we'll have to write 3 different
My
judgments.
lord, I understand. My lord. That is my.
So let us consolidate it
My lord.
that as to what should be the proper judgment by giving us case laws.
My lord. My lord. My lord.
When you say something,
My
it has to be supported by reason.
My lord.
When a judgment is passed, it has to be supported by reason.
My lord.
I cannot say that as per the humble understanding of
My
the
lord, I
petition
understand.
appellant's counsel,
My
this
lord.
is the law.
My lord,
I cannot say that.
I understand.
So please help us, help you.
I understand, my lord. That regarding that judgment part, my lord, right now I don't have, my lord. If lordship grants me
No,
time till 2
there's no
p.m.
point, no point. We have given you enough time, and this court also on the last date has given you last chance.
My lord, I understand.
So no further adjournment.
My lord, I understand. I understand, my lord.
You can, after we can take it up at 2, within 45 minutes, you look for
My lord,
judgment.
I will search, my lord.
So, anything, madam? Have you finished? Anything else?
Well, regarding the sketch map, my lord, there is no indication about the house of PW5. That is, my lord. That's why she is seeing the occurrence from her house, my lord. Possibly that also is doubtful. That is my humble submission. And Dow was also not sent.
Let us see the sketch map.
Page 59, my lord.
Page 59.
My lord. This is the place of occurrence, my lord. 60 lordship will find the descriptions, my lord.
A is the place of occurrence.
My lord. B indicates the house of Deepak Das.
Okay, so your case is that the sketch map
My lord.
does not show the house of
PW5, my lord.
so because of that, so what is your case? What is your submission?
My submission would be, my lord, she is seeing the occurrence from her house, my lord. That possibly is that part is she is lying, my lord, because she did not see the occurrence. That I may want to make that submission, my lord, because she has stated that from her house she saw the occurrence.
Did you put this question to the?
No, my lord. No question was put, my lord.
That's all.
My lord.
Okay, we'll take it up at 2.
My
To
lord.
my lord.
I'll try to find out some. Oblige, my lord. My lord, I have submitted, my lord. I could find some of them, my lord, possibly, my lord. It may help, may not help, my lord. The first one, lordship will take up 2012 4 SCC 379, my lord. Para 12, my lord. Para 12. Here, actually, this is in respect of lodging of prompt FIR, my lord. Para 12, may I read, my lord? The FIR is in a criminal case is a vital and valuable piece of evidence, though may not be substantive piece of evidence. The object of insisting upon prompt lodging of the FIR in respect of commission of an offence is to obtain early information regarding the circumstances in which the crime was committed, the names of actual culprits, and the part played by them, as well as name of eyewitnesses present at the place of occurrence. If there is delay in lodging FIR, it loses the advantage. My lord, here, my lord, in the facts and circumstances of the case, my lord, the FIR was, I cannot say that it was lost delayedly, my lord, but it was promptly lost within 5 hours. Then also, my lord, the absence of names of these eyewitnesses, my lord, possibly they later on projected to be eyewitnesses in the case. They have been projected by prosecution, my lord. Which means they have been projected to be eyewitnesses. My lord, actually, in fact, in my submission, my lord, they were not the eyewitnesses of the occurrence. Second one, my lord, will pick up, my lord, 2021 5 SCC, my lord, 572, my lord, paragraph 5, my lord. Basamma PW 5, may I read, my lord? Basamma PW 5 in her examination in chief had stated that after midnight of 19/4/99 to 24/99, she had heard a sound which she described as thuk. This appears to be a phonetic description of what may be called a thudding sound. This also stated in her examination in chief at Honappa and Nagaraja, their sons were sleeping with her husband. On hearing such sounds, she shouted, and on opening her eyes, she saw the appellant Malappa with a club assaulting on the head of the husband, with Virappa A2 standing behind him. In cross-examination, she stated that Honappa was not sleeping with them on that day, as she was in Sindhipur. Her daughters Enamma and Garamma were sleeping with them. As regards witnessing the accused persons, her varied version in a cross-examination was that by the time she had woken up and saw her husband injuries had been caused. Here also PW5 says, my lord, she did not see the assault but saw the deceased falling down on the road. Coupled with the fact that, my lord, her house does not find, my lord, in our case, my lord, PW5 says, my lord, in chief examination, she says, my lord, she had seen the assault. But in cross, she said, I did not saw the assault, but I saw that deceased fell down on the ground. PW5, my lord. Last line, my lord. I did not see when the blow was inflicted on another, but I saw the deceased fell on the ground. And coming near the deceased, I found that blood was coming from his body. My lord. And informant also is a relative, man. Well, I understand. And the last one, my lord. 2021, my lord, 1 SCC 118. Page para 21, my lord. PW4 married, my lord. PW4 in the course of cross-examination stated that PW5 and one unknown person had lifted Sandeep from the 21 minute. PW4 in the course of cross-examination stated that he, PW5 and one unknown person had lifted Sandeep from the spot to take him to so-and-so Rohtak. On the other hand, PW5 in the course of his deposition does not mention the presence of any third person who took Sandeep with them to the hospital, while PW4 states that the police reached the hospital at 4 p.m. PW5 on the other hand is unaware of when the police had reached the hospital. Now in this background, it is important to notice that there are clear improvements made by PW4 and 5 which have a bearing on whether they were eyewitnesses to the alleged occurrence. Both PW4 and 5 have made substantial improvements in their course of their examination in evidence. Both the witnesses attempted to bolster the case of the prosecution with regard to their presence at the scene of crime and of being eyewitnesses of the occurrence by stating that they have removed Sandeep to the hospital after he had been gunned down. The absence of any reference to their taking Sandeep to the hospital in affair has a bearing on whether they were eyewitnesses to the occurrence. Here also PW1, my lord, if she is believed 3-5 absent, my lord, in her evidence. So my humble submission is PW3 and 5, my lord, has been projected to be eyewitnesses, my lord. In fact, they were in fact not the eyewitnesses, considering their contradictory statements. And thou in question seized, my lord, not sent for FSL also. That's my lord.
Lordship, in the case in hand, your lordship, FI was lost, my lord. It was lost on 5/9/2010 by the informant.
Same day.
Same day. The lordship, here the evidences of PW1, 2, 3, and 4. The circumstances which goes against the accused persons are as follows, my lord. PW1, here the daughter of the informant as well as the daughter of the deceased. She's no to PW1, the daughter of the informant who happens to be the lordship child witness, my lord. Although she was not cited as a witness, my lord, she informed the matter about the assault made by the accused person, my lord. Then thereafter, the PW1 saw the accused person running away with a dog. Running away, that's the circumstance which goes against the accused person. She saw the accused person running away with a dog. Then she saw cut injuries on neck and chest, my lord. And your lordship, there are even the son of PW2 happens to be the son of the lordship victim as well as PW1. He saw cut injuries in the neck and the chest, my lord, and there is oral dying declaration to him by the deceased, my lord. To him, to PW2, your lordship. PW2, son of the deceased, yes. Then PW3, your lordship, Kuleswari Das, she is the eyewitness to the incident, saw accused hacking Nana Das with a dao, my lord. PW5, who is related to both the sides, accused as well as the deceased, my lord. She saw altercation, my lord. And she also saw accused person assaulting the deceased, my lord, with a sharp cutting weapon. Then your lordship, dao was seized, lordship, and all the witnesses They have whatever they have revealed, it's a weapon of assault is same, your lordship. And as per the evidence of the doctor, the injury was on the vital part of the body. May I take your lordship to the evidence of PW1 first, my lord? Somebody minor does. Page 10. I know accused Moina Das. This is Nena Das was my husband. Around 3 p.m. about 4 years ago, I went to the nearby shop. I went to a grocery shop. My daughter Dipamoni Das came at a run and told me that accused Moina Das had cut her father. Then I came running and saw my husband lying under a tree at the gateway of my house. I saw cut injuries on the neck, chest and hand of my husband. While returning from the shop, as I was about to reach my husband, I from a distance of 10 meters saw the accused running away with dao in his hand. When I reached my husband, two persons, namely Moon Das and Krishna Das, were helping my husband drink water. A neighbor came and called a 108 ambulance. An ambulance came and took him to Kanakota Civil Hospital, Teshpur. My husband died at a hospital around 5-10 minutes after he had been taken to that hospital. Then I lost a written Azahar in the Bebeji outpost under Teshpur PS. I lost the Azahar at 8 p.m. On the day of occurrence itself, a person wrote the Azahar on my behalf. I put my thumb impression in the Azahar after it was written as per my person and was read over to me. I put my thumb impression in the inquest while police held inquest on the body of the deceased. Police came to my house, that is the place of occurrence, around 3 p.m. the following day of the incident. My husband was lying in an injured state under a banyan tree at the gateway of my house. The distance between my house and the banyan tree is about 5 meters. Police examined the place in which my husband was lying. I was there during the inspection of the place. There was grass and stones at the place of where my husband was lying. Police did not seize anything from the place of occurrence. The distance between the banyan tree and the shop where I went is about 50 meters. My daughter Dipamoni is about 10 years old. She informed me about the incident. The name of the shopkeeper is Baba Soikia. He did not come to the place of occurrence. First I met Munu Das and Krishna Das, and other people came later. When I arrived near my husband, he held me on the road that Moina, I will die. There was no other person near me when my husband told this to me. It is not a fact that I did not see the accused running away with a dao in this hand. The old house of the accused is about half a mile away from the place of occurrence. I got the Azahar written in the PS itself. Police person were there at the PS. I went to the shop by the side of the banyan tree. At that time, there was no one under the banyan tree. It is not a fact that I stated that my daughter had informed me when I was at the shop itself. Then, your lordship, PW2, Choto Das. He saw, lordship, a second paragraph. He is the son of the deceased, my lord. He saw cut injuries on the neck and chest of his father, your lordship. And about the oral dying declaration at page 14, my lord. On being asked, my mother told me that accused Moina Das had cut my father and fled. My father said to me, Moina has cut me and fled. What are you doing? So there is oral dying declaration, my lord. Dying declaration.
Yes.
So it remained unshaken. It was not proven, lordship put to him in cross-examination, my lord. So it remained unshaken, my lord.
He was not crossed in this aspect.
No, on the, I don't think it's not crossed, my lord.
No, suggestion was put, my lord.
Put to page.
It is not a fact, page 15, my lord. It is not a fact that father did not tell me that accused has cut him. Page 15, my lord. And regarding dying declaration, my lord, PW2 is silent. When PW1 says that she was alone with her husband, and PW2 says, my lord, his mother was also with him. But PW2 is silent about DD, dying declaration.
Lordship, at the relevant point of time, somebody is calling the ambulance, somebody is like trying to save, pouring water, somebody is giving water to the deceased, my lord. So, lordship, it's not that the PW1 will say everything, my lord. So, your lordship, PW2 says about dying declaration, my lord. Then PW3, she's the eyewitness, my lord. Full story does. line 4, page 16. I saw the accused hacking Nana Das with a dao on the road of village Bahmari. I saw him hacking on his chest, neck and hand. So it, Lordship, corroborates the evidence of the doctor, Your Lordship, the injury on the vital part, chest, hand and neck. Lordship. Then, my lord, Bokuli Das, who is related to both the sides, my lord, PW5, my lord, she is related to both the accused as well as the deceased, my lord. So she talks about the altercation and she talks about the assault. This is Nana Das with a sharp cutting weapon. I saw that accused Moina, 1, 2, 3, 4, fifth line, Lordship, fourth line. There was altercation between the deceased and the accused. I saw that accused Moina Das assaulted the deceased Nana Das with a sharp cutting weapon. I saw cut injury on the chest of the deceased. So, Your Lordship, regarding non-informing, my learned friend's version, submission, my lord. Non-informing that PW1 does not say about PW3 and informant's daughter not examined. It's not fatal, Your Lordship. And my lord, encyclopedia, FIR is not an encyclopedia. It should not disclose each and everything, my lord. It's given at the laws at the first inception, my lord. So entire fact might not be there. Elaborate things might not be there in the FIR, Your Lordship. So it's not fatal to the prosecution. So, Your Lordship, regarding PW5, she is also an eyewitness. So, Your Lordship, she is related to both the sides. She will not lie against the accused person, my lord. That accused person hacked the deceased, my lord. She is her own grandson, my lord. He is her own grandson. So, Your Lordship, I think prosecution has to prove beyond all reasonable doubt. The chain is complete, my lord, that the accused person is the perpetrator of crimes. And evidence says there was previous enmity, so there might be intention, my lord. And it's not that Your Lordship.
Where does it say previous enmity?
Enmity is there, Your Lordship. There some cases were lost.
PW2, my lord. PW2, my lord, with kindly. PW2, my lord. There are some suggestions given to this witness, page 14. Cross-examination part, my lord. I regard Upendas as my board deuta, but he is my own board deuta. It is not a fact that prior to the occurrence, I assaulted accused and fractured his head. This
Prior to
PW2.
that, paragraph 3.
It is not a fact that.
Paragraph 3 does, sir. Lordship, cross-examination, paragraph 3, page 14.
I regard Upendas as my board deuta, father's elder brother, but he is my own board deuta. It is not a fact that prior to the occurrence, I assaulted the accused and fractured his head. It is not a fact that I assaulted the accused with lathi, thereby causing grievous injury to him.
No, my question is, what is the enmity between the petitioner, between the appellant and the deceased?
No, Lordship, there are lodging of cases and also the suggestion is given in a cross-examination. Paragraph 3, the accused got married to my sister's daughter. It is not a fact that Moina Das lost several cases against our family earlier. The suggestion was given.
That is a suggestion,
Yes.
but where is the suggestion? That doesn't say anything.
Apart from that, there is nothing. So, Lordship, I think prosecution has to prove beyond all reasonable doubt. It's on the vital part of the body. So, a general exception will
There
not
is
be there.
one thing. Okay, assuming that mens rea has been proved.
Yes.
I mean, mens rea, actus reus has been proved.
Yes.
Where's the mens rea?
But Your Lordship, there was, it's not a case that there was.
Was there any motive or anything? Was there any
Motive
reason?
or intention maybe from the earlier enmity regarding because they had
Where is
cases.
where is the evidence to that effect?
Suggestion is given. It's not a paragraph 4, as my learned friend has read, my lord. It is not a fact that prior to the occurrence, I assaulted the accused and fractured his head. It is not a fact that I assaulted the accused with lathi, thereby causing grievous injury to him.
In that event, my lord, possibly PW2 have been assaulted. My lord, not PW2 है हमारी से.
Regarding lodging of cases also that the suggestion has been put. So they have implicated. But it might be a fact because prior enmity is there. So weapon use your lordship take into account. It's a Dow, your lordship. Dow.
Intention.
Yes, on the vital part.
But the motive is we do not.
Motive may not be there in all the criminal cases, your lordship. May I cite certain issues?
Yes.
State of Rajasthan through the Secretary versus Kanhailal 2019 5 SCC 639. I'm sorry, your lordship, only two. I'm sorry, I'll read out your lordship. Lordship, I'll read out. There are 7.
Yeah, read out.
Heard the learned advocates appearing for the respective parties at length, we have considered in detail the judgment and order passed by the learned session court, as well as the impugned judgment and order passed by the High Court. The learned session court convicted the accused for the offence under Section 302. However, in appeal preferred by the accused, the High Court has converted the conviction from 302 IPC to Section 304 Part 1 IPC. While doing so, the High Court has assigned the following reasons in paragraph 15. In the circumstances of the case, it is proved beyond doubt that Rajmal had died because of single injury caused on his head by appellant, accused Kanhailal by an axe. It is also an admitted fact that there was no repeated injury, and furthermore, it is also on record that it is the morning of the day of the incident. There was an altercation between the accused and the deceased. And so it can be said that in the circumstances of the case, that there was no intention to cause death on the part of the appellant accused, but the act by which the death was caused appears to have been done with the intention of causing such bodily injury as is likely to cause death. And so his conviction observes to be altered from Section 302 of the Penal Code to Section 304 Part 1 of the IPC. Now, so far as the main reason given by the High Court while converting the conviction from 302 IPC to Section 304 Part 1, it was a case of a single blow is concerned. It is required to be noted that the deceased had died because of single injury caused on his head by the accused by an axe. Therefore, it can hardly be a ground to convert the conviction from 302 IPC to Section 304 Part 1. In Arun Raj, this court observed and held that there is no fixed rule that whenever a single blow is inflicted, Section 302 would not be retracted. It is observed that and held by this court in the aforesaid decision that nature of weapon used and vital part of the body where blow was struck proved beyond reasonable doubt the intention of the accused to cause death of the deceased. It is further observed and held by this court that once these ingredients are proved, it is irrelevant whether there was a single blow struck or multiple blows. In Ashok Kumar Magabhai Bhankar, the death was caused by a single blow on head of the deceased with wooden pestle. It was found that the accused used pestle with such force that head of the deceased was broken into pieces. This court considered whether the case fall under Section 302 or exception 4 to Section 300. It is held by this court that the injury sustained by the deceased not only exhibits intention of the accused in causing death of the victim, but also knowledge of the accused in that regard. It is further observed by this court that such attack could be done other than for causing death of victim. It is observed that any reasonable person with any stretch of imagination can come to conclusion that such injury on such a vital part of the body with such a weapon would cause death. A similar view is taken by this court in the recent decision Leela Ram, and after considering a Katana decision of this court on the issue of on hand, that is, in case of a single blow, whether a case falls under Section 302 or 304 Part 1 or Section 304 Part 2, this court reversed the judgment of the High Court. In the case also, the judgment impugned was from the Rajasthan High Court and convicted the accused for the offence under Section 302 IPC. In the same decision, this court also considered exception 4 of Section 300 and observed in paragraph 21 as under. Under exception 4, culpable homicide is not murder if the stipulations contained in the provisions are fulfilled. They are that the act was committed without premeditation, that there was a sudden fight. The act must be in the heat of passion upon a sudden quarrel. The offender should not have taken undue advantage or acted in a cruel or unusual manner. Applying the law laid down by this court in the aforesaid decisions to the facts of the case on hand and the reasons given by the High Court while converting the conviction of 302 to Section 304 Part 1, the reasons stated in para 15 of the impugned judgment and order, we are firmly of the view that the judgment of the High Court is manifestly perverse, is totally contrary to the evidence on record. As per the deposition of PW1 Dr. K. Asif, the deceased sustained following injury, so and so. Lordship's detail is given. Then, Your Lordship, para 9, another reason given by the High Court is that there was no repeated injury. The aforesaid can hardly be a ground to convert the conviction from 302 to 304 Part 1. A single blow on the vital part of body, like head and that too by deadly weapon X and used with force which proved to be fatal was sufficient to hold that it was a case of murder within the definition of 300. So it was, Lordship, appeal was dismissed. 2 courts below have allowed the appeal, my lord. One allowed, one Lordship dismissed, one allowed, and it was interfered by the Supreme Court. Regarding the first information report, my lord, should not.
No, so why have you placed this judgment in support of which submission of yours?
Lordship, if
He's
your
not
Lordship
asking-
holds because one of the witnesses have revealed there was altercation, my lord. If the case comes under, because grave and sudden provocation, although he did not come from him, my lord.
Then
So Lordship, if
that
it is on the
that
vital.
a different case.
No, if it is on the vital part of the body, even if there is single blow, if there is premeditated in a sudden
Is-
fight,
that
my
is-
lord,
that is-
not his case.
that is not
If
case.
he takes that plea, Lordship, if it is Lordship, if he tries to bring it under general exception, if it's on the vital part of
He's
the
not-
body,
he's not on the
law,
generous
no.
case.
then it will not come, my lord. So your Lordship will uphold the judgment of the learned trial court. And regarding that, your Lordship, that the FIR should disclose the names, my lord, para 24 and 25 of 2016, 4 SCC 371.
One copy.
Only one copy, I'm sorry, your Lordship.
No, it's okay, it's okay. Which para?
Para 24 and 25, regarding whether it should be named.
What does it say?
Para 24, in addition of Mrityunjay Biswas in para 22 and 23, this court, by referring to the earlier decisions, has noted the legal principle as to how a person not named in the FIR when proceeded against can be considered. Para 22 and 23 can be usefully referred to which are as under. In Mullah versus State of UP, the accused persons were not named in the FIR. Taking into consideration the material brought on record, the court observed that though none was named in the FIR, yet subsequent the names of the appellants had come into light during investigation. And hence, non-mentioning the names of the accused persons would not be fatal to the prosecution case. In Ranjit Singh versus State of MP, after referring to the authorities in Rohtas versus Ratan Singh and so, the court opined that in case the informant fails to name a particular accused in the FIR, the said accused is named at the earliest opportunity. When the statements of the witnesses are recorded, it cannot tilt the balance in favor of the accused. When we apply the above principles to the facts of this case, we are convinced that the implication of all the 5 accused was perfectly justified and was supported by legal evidence as was spoken by relevant witnesses, which is duly corroborated by the medical evidence. Therefore, mere non-mentioning of the 2 of the names in the FIR cannot be fatal to the case of the prosecution.
But in this case, what he wants is the names of the witnesses.
Yes,
That is his case.
yes.
That's on a, so that's even on a more weaker wicket. Nowadays, the accused name should be there.
Right.
Yours, you want the witnesses,
Witnesses.
everything.
But it's a subtle law, my lord. FIR should not, every fact may not be there in the FIR, man.
It is true, it is
Yes,
true.
yes.
Anything else?
Lordship, others, the prosecution could prove, my lord, informants that are not examined, that's not fatal, your lordship.
Informants were not,
Daughter, she says, my lord, informant's daughter was not examined. She only reported informant.
how does it matter?
No, it doesn't
How
matter.
does it
Doesn't
matter?
matter. It's not material, my lord.
Not only informant, daughter, my lord, 2 other characters, my lord. Moondas and Krishna Das, whom PW.
Okay, those two persons.
My lord. Then, my lord, withholding this
Informant's daughter, and then those two
Moondas and
persons.
Krishna Das, my lord. Or withholding these two persons, my lord, possibly, my lord, 114Z, that adverse inference can be drawn because they were the persons, my lord, 114Z of evidence at my lord.
Were they made witnesses in the charge sheet?
Oh, they,
The Moon Das and Krishna Das?
yes. No, my lord. They are not witnesses. Lordship, not fatal, Lordship, because the other
How is it
witnesses.
fatal to the
My
Yes.
lord,
prosecution?
may I read 114G, my lord,
114G
my lord,
of the,
evidence at my lord,
yes.
for 1 minute, my lord, for 1 minute. It starts, court may presume existence of certain facts, my lord. 114, my lord. 114G, my lord. That evidence which could be and is not produced could, if produced, be unfavorable to the person who it holds it.
Have you got 14G?
Illustrations, my lord.
No. That evidence could be.
My lord, that evidence which could be and is not produced could, if produced, be unfavorable to the person who withholds it. So prosecution might have withheld these two witnesses with no explanation, my lord. And one more thing, my lord, that fleeing away, PW1 saying that she saw the accused fleeing away with a dao, my lord.
Yes.
That aspect, my lord, possibly my one judgment I have placed before your lordships, my lord, that 2021 5 SCC, my lord.
Yes.
2020 para 14 may kindly be looked into for a once, my lord. Lordship has got it, my lord. Even if prosecution version that PW3, 5 and PW6 could and did see the appellant running in front of Devan Rappa's house from the respective positions they were in at the time of occurrence of the incident was accepted, the evidence would have been left with would have been two accused persons being seen running away. That would have been too thin piece of evidence to convict someone under section 302 Indian Penal Code. Applying the principle res geste, the first court of facts on appreciation of evidence had acquitted the appellant.
You're reading which paragraph?
Para 14, my lord.
14.
1-4, my lord. 2021 5 SCC, my lord. 572,
Para 14, yes.
my lord. Even if, my lord, lordship has got my lord. Even if prosecution version that PW3, 5 and 6 could and did see the appellant running in front of Devan Rappa's house from the respective positions they were in at the time of occurrence of the incident was accepted, the evidence would have been left with would have been two accused persons being seen running away. that would have been too thin piece of evidence to convict someone under section 302 of the Indian.
That is the only, but that is not the only evidence in this case.
My lord,
Yes.
that is why, my lord, if lordship, my lord, doesn't consider PW 3 and 5 to be trustworthy, my lord, then PW 1 remains, my lord. That is why I am submitting. And regarding the Dow also, my lord, in that same judgment, paragraph 13 may be looked into.
13.
13, my lord. Because Dow in rural areas, my lord, it is found everywhere. Here, my lord, club was used, wooden club, my lord. Para 13, may I read, my lord? We have already reproduced the part of deposition of Srinivas PW to the Caesar witness in which he has stated that the club was not broken. PW1 has also deposed on spot punchnama made by the police on the morning on 24 to 1999 from the place of occurrence. He also does not speak of seizure of the broken piece of club. These two prosecution witnesses do not support the statement made by PW by the inquest officer in his examination that the latter had seized a small piece of wooden club. The autopsy surgeon so and so was not shown that club. It does not transpire. So from his deposition, club is a common implement which can be found at random in rural households of this country and in the absence of any cogent evidence demonstrating that the club seized was used to assault the deceased. The prosecution is seeking to establish commission of the offense by circumstantial evidence of discovery of the weapon of offense fails. Here it is Dow, my lord, in rural areas, my lord. Dow is found in everybody's house, my lord, and not subjected to FSL examination. My lord. The connection that Dow was used for the assault. That is my humble submission.
Lordship, section 114G of the Evidence Act may not be applied, may not, will not apply, because your Lordship, in a case where the doubt should come into the mind of the Lordship court, my lord. The court may presume the existence of any fact which it thinks likely to have happened. In the case in hand, your Lordship, the case was proved beyond all reasonable doubt. Regard being had to the common course of natural events, human conduct, and public and private business in the relation to the facts of the particular case. Then G, that evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. So in the case in hand, there was no Lordship, no that another story would come. It's not a record. It has Lordship, the chain is complete, your Lordship. So beyond a reasonable doubt, the case was proved, my lord. So my
What is this
submission.
judgment that you have given 2019-5?
Lordship, that's a repetition. I have given the extra copy. I have given the extra copy.
Oh, this is the extra
yes,
copy.
Yes.
Yes, I've got one. That's all?
Mine.
Okay, right. Heard, Mr.
N.J. Das, my lord.
N.J. Das, learned amicus curiae, appearing for the appellate. No, just a learned amicus curiae and Miss B. Bhuyan, additional PP. This appeal has been filed against the judgment and order dated 28/9/2021. No, judgment and order dated 23/9/2019, passed by the additional sessions judge Sonnet Court, Test Court. In sessions case number 64/2014, by which the appellant has been convicted under section 302 IPC and sentenced to undergo life imprisonment with a fine of ₹5,000, in default, rigorous imprisonment for 3 months. The facts of the case in brief is that the prosecution case in brief is that the wife of the deceased submitted an FIR on 5/9/2010, stating that around 3:30 p.m., the appellant had waylaid the deceased and dealt blows on him with a dowel, causing injuries. The deceased was taken to the hospital. They was taken to the Kanak Lata Civil Hospital, Tesco, where he succumbed to his injuries at 7 p.m. on the same day. Based on the FIR, Tezpur PS case number 829/2010 under section 341, 326, 307, 302 IPC was registered. First up, after conclusion of the investigation, charge sheet was filed against the appellant as a prima facie case under section 326/307/302 IPC was found against him. Charge was framed. Just a minute. 4 charges were framed against the appellant. No, 3 charges were framed against the appellant under section 326, 307 and 302 IPC, to which the appellant pleaded not guilty and claimed trial. Next para. During the trial proceedings, 7 prosecution witnesses were examined. Thereafter, the appellant was examined under section 313 CRPC. Wherein he took a stand that a false case had been filed against him. The learned trial court thereafter, having come to a finding that the appellant was guilty of the offence under section 302 IPC, convicted him and sentenced him to undergo life imprisonment with a fine of rupees 5,000. In default, RI for 3 months. Next para. The petitioner's counsel submits that the evidence of PW number 1 is to the effect that she saw her husband lying under a tree at the gateway to her house with cut injuries on the neck, chest and hands. She also saw the appellant running away with a dove in his hand. And when she reached her husband, two persons, namely Moon Das and Krishna Das, were helping her husband drink water. Gustav. PW number one had also, no, Gustav, though PW number one's evidence is to the effect that she was told of the occurrence of the event by her daughter, her daughter has not been made a witness by the police, by the prosecution, and neither has the daughter been examined by the court. With regard to PW number two, what have you got to say?
PW number 2, he is not, he did not see the occurrence, my lord.
Okay.
Regarding the dying declaration, my lord,
Ah.
lordship will kindly come to page 11, my lord.
Yes.
Page 12 rather, my lord. Second paragraph, last line. There was no other person near me when my husband told this to me. Her husband said that Moina, I will die. This was allegedly stated by the deceased. Now PW2 says, my lord, that lordship will come to page with all respect.
The wording is different out here.
My lord. Moina is the informant also. The
Yes.
informant's name is Moina.
Yes.
Now PW14, my lord. When my father, page 14, my lord, when my father was lying under the banyan tree, there was no one except my mother. So he and mother, according to him, were together.
Okay, right. What have I said? He also submits that the evidence of PW number two, who is the son of the deceased, is to the effect that his deceased father had told him, inverted commas, Moina has cut me and fled. Full stop. What are you doing? Question mark, inverted commas. Full stop. He submits that the said. He submits that as per the evidence of PW number one, no one was present when her deceased husband had told. No, cut that. He just submits that there is a contradiction between the evidence of PW2 and PW number one, as PW number one had stated that there was no person near her when her husband had told her, inverted commas, Moina, I will die. Moina, comma, I will die. But the words are different. Different. Yes. Nothing. Next paragraph. The learned amicus curiae also submits that though PW number one had stated in her evidence that Moon Das and Krishna Das were helping her husband drink water, the evidence of PW number three, who is an eyewitness, who is an eyewitness, does not speak of the presence of Mona Das and Krishna Das. He also submits that Mona Das and Krishna Das were not made prosecution witnesses by the police and neither were they examined by the court. He accordingly submits that the omission of PW number 3 with regard to the presence of Moon Das and Krishna Das shows that PW number 3 was not an eyewitness to the occurrence. Full stop. The learned amicus curiae also submits that the evidence of PW number 5, who is an eyewitness, cannot be admissible in evidence as the evidence of PW number 5 shows that she had poor eyesight. Full stop. Accordingly, she could not have seen the incident. Correct. Full stop. Further, though PW number 5 has stated in her evidence that the occurrence took place on the road in front of her house, the sketch map of the place of occurrence does not contain the house of PW number 5. As such, in all probability, PW number 5 did not see the incident. Full stop. The next para, the learned amicus curiae also submits that the evidence of PW number 6, who was a Caesar witness, shows that he had not seen the Caesar of the dao bracket weapon. First stop. He also submits that the dao had not been sent to the FSL for examination. So what happens if you don't send it for examination?
Considering the facts and circumstances of the case,
What happens? What does the Supreme Court say if you don't send it for examination?
In case of circumstantial evidence, if Lordship considers 3 and 5 to be not eyewitnesses,
Okay,
then it assumes significance,
correct.
to connect the doubt.
But where is the judgment? There is judgment. And anyway, full stop. He accordingly he just submits that as the evidence of PW number 3 and 5 cannot be made the basis of the conviction of the appellant, as they were not eyewitnesses. As such, the absence of having a FSL examination of the dao was extremely necessary. The same not being done, the petitioner, the appellant has to be acquitted of the charge under section 302 IPC and released from jail. Acha, one more thing you just said. The learned amicus curiae also submits that as the daughter of the informant who had apparently informed the informant bracket PW number 1 with regard to the injury suffered by the deceased and the fact that Mohandas
Moondas and Krishna Das.
Mohandas and Krishna Das were not made prosecution witnesses, this court may presume that there were unfavorable evidence or what?
And they would have been unfavorable to the prosecution
That
side.
there were evidence which were unfavorable to the prosecution in terms of section 114 of the Indian Evidence Act. 1872. That's all, I think. Acha, wait. Then his citations. So one more thing. Yeah, next para. The learned counsel for the learned amicus curiae submits that the FIR submitted by the informant does not reflect the names of Moon Das and Kishore Das.
No, my lord, this PW 3 and 5.
Does not reflect PW. Does not reflect the presence of PW number 3 and 5 at the time of occurrence of the incident, despite PW 3 and 5 being eyewitnesses, being alleged eyewitnesses to the crime. To stop. He submits that not only has an FIR to be lodged promptly, promptly with first-hand account of what actually happened, but the persons who are responsible for the offense in question should also be reflected in the FIR. In this respect, he has relied upon. How does the responsible person are already reflected in the FIR? These are eyewitnesses. In this respect, he has relied upon the judgment of the apex court in Jai Prakash Singh versus State of Bihar and others, reported in 2012, 4 SEC 379. Next para. In support of his submission that the prosecution should establish the seized dove to be the weapon used for assaulting the deceased, by having an FSL examination done, the learned amicus curiae, wait. And the reliance on the evidence that the appellant was seen running away from the scene of a crime was too thin a piece of evidence to convict a person under section 302 IPC, the learned counsel has relied upon the case of Mallappa versus State of Karnataka 2021 5 SCC 570. Full stop. Next para. In support of his submission that there are clear improvements made in the evidence of PW number 3 and 5.
3 and 5.
With regard to them being eyewitnesses to the alleged occurrence of the crime, which cannot be done. He has relied upon the judgment of the apex court in Rajesh alias Sarkari and another versus State of Haryana, reported in 2021 1 SCC 118. Next para. Miss S.B. Bhuyan, Miss B. Bhuyan, learned additional PP. On the other hand, submits that there was no delay in lodging of the FIR. She also submits that an FIR is not an encyclopedia where all the factual details of the occurrence of the crime and all the witnesses are required to be mentioned. She submits that the evidence of the prosecution witnesses clearly goes to show that the appellant had caused the death of the deceased by inflicting blows with a dowel. She further submits that the oral dying declaration made by the deceased to PW number 1 and PW number 2.
Only PW2,
my lord.
PW number 2. PW2.
2, son. Photo does, son.
Is 14, my lord.
No, but what about in the cross-examination at page 12?
Right.
Page 12.
When I arrived near my husband, he told me on the road that Moina, I will die. Moina is name of the informant also, my lord.
Okay,
His wife.
informant. Okay.
Well.
Oh, okay. He's number 2. Moina is number 2. Moina is number 1.
Number 1, my lord.
That's what.
Yes, PW1.
So he has made an oral dying declaration to Moina and to number 2 also. And the number 2 is?
Number 2 is the son.
Yeah, yes. So number 2 to number 2 also.
No, to PW1, he said that
Moina?
he will die.
Ah.
To PW2, he said Moina has attacked, Moina has killed him.
Correct. So
Yes.
both are oral dying declaration.
PW1 to PW1 may not be the dying declaration.
Why?
You know?
Calling his wife as Moina,
Moina.
he said that I will die.
Oh, I will die.
Yes.
Okay, okay. What have I said? PW2. Further corroborates the fact that the that the appellant had caused the death of the deceased. Full stop. The learned additional PP submits that non-mentioning of the names of the witnesses in the FIR is not fatal to the prosecution. And in fact, the apex court, as in the case of Susanta Das and others versus State of Odisha, reported in 2016 4 SCC 371, held that non-naming of accused persons could not be fatal to a prosecution case. Full stop. She thus submits that if the non-naming of accused persons in an FIR is not fatal to the prosecution, comma, the non-naming of eyewitnesses cannot be fatal to the prosecution. That's all. That's all. She accordingly submits that as this is a clear-cut case of murder, the impugned judgment and order should not be interfered with. Then,
And evidence of eyewitnesses, my lord,
uh,
PW 3, PW 4 are reliable, your lordship.
First of all, also right. She also submits that the evidence of the prosecution witnesses are reliable and have not been shaken in the cross-examination. You put that somewhere. Then hearing concluded, judgment reserved. Okay. You're an amicus.
Mine.
You see, one thing I do not know how you write at the end. Do we write the amount or we write the appropriate fee should be
Yes,
paid?
this one, legal services retreat, they will,
They will. So I just have to write appropriate
yes,
fee.
yes,
I don't have to say the
No.
amount.
Mine.
Correct?
yes.
Mine.
Okay. Pretty much shoots.
Deeply obliged.
Motion filed with anybody, no? Why not to see, you know? Same, yes, sir. Why did you file it? Yes, जागा नहीं. I say.